Guys. Hey, all persons of any duty fully honorable to justices, the appeals court, now sitting in Boston, far away from the Commonwealth. Draw near and give your attendance, and you shall be heard. Once in the Commonwealth of Massachusetts, this court is now open. Please be seated.
Okay, thank you very much for that, and good morning, everyone. Welcome to today's sitting of the Appeals Court. I'm just going to start by introducing the panel. To my right is Justice Joseph Ditkoff, and to my left is Justice Andrew D'Angelo, and my name is Ariane Vuono. We're taking one case out of order this morning. We're going to hear what was scheduled to be the sixth case first. We're sorry for the reasons why you were not able to be here last time, Counselor, and thank you to the Assistant District Attorney for coming here a second time. So we're going to hear that case first. Let me just remind everybody that you have 15 minutes to present your argument to us, that we've read everything that you have submitted to us, and so you can get right to your most salient points. 15 minutes is not that long. On the other hand, if you don't need the full 15 minutes, you're not required to use them. I always like to remind everybody that there is no rebuttal in the appeals court in Massachusetts. With those
May it please
housekeeping matters, excuse me, both housekeeping matters done, then we'll hear argument. Let's start right now. Thank you. Good morning.
May it please the court. Just as a personal note, I do appreciate the kindness that was shown to me, my family, in the last time we were here. We were supposed to be here.
Of course.
And I also appreciate the consideration of my sister. Regarding the case, Commonwealth versus Horsley, my name is Dan Ciccarello, and I represent the appellant. And I will thank you for an opportunity to address you regarding it. As I see it, the appeals court has three options. The first option is to side with the Commonwealth and find that my client was able to hear and there was no structural error, and to give more weight to the trial judge's reminiscence as opposed to the transcript or to Dr. Grunfest's affidavit. Or you could find that the lawyer was ineffective at trial, which is one of my arguments, and I would suggest to you that my client had told the lawyer that he couldn't hear, that the lawyer told the court, so he knew that my client couldn't hear, had a problem with hearing, and that at several times my client had said that he couldn't hear in court, and that the lawyer's job was to, under Commonwealth versus Elliott, particularly dealing with hearing impaired people, he has an obligation to tell the court.
Can I ask you a question about that? You've just indicated that there was a couple of times that appear in the transcript where your client indicated that he couldn't hear. And on each of those occasions, the judge responded, if I've read the transcript correctly, right? On each of those occasions, the judge addressed the situation. And then there was no further comment by your client, that's recorded anyway on the transcript, and the lawyer. What do you say about that? I mean,
well, there were two instances that he said he couldn't hear. The first was with testimony with the, I believe it's on page 31, right before the police officer was going to testify, he said he couldn't hear. And then later, right in sentencing 113. Now, I would suggest to you that the judge had said prior on page 26 in the opening statements, saying, I think you have to speak up. And I would suggest to you that that was okay, but it wasn't appropriate. My client could not hear. He had problems with hearing. He had no hearing aid that he had left in the place when he was rushed out by the police. And so I would suggest to you that that is, considering how bad my client is affected by hearing loss, that would not have been appropriate. That it was either the lawyer's
I guess
ability—
not putting words in your mouth, but your point is that it's not significant that there was no follow-up after the judge simply said, everybody speak up. That was not sufficient, and the fact that there was no follow-up on the part of your client or the lawyer is not significant in this case. Is that your point?
Well, I think that the lawyer should have, the lawyer knew that he had a hearing loss. He should have said, Your Honor, that's not appropriate.
That's part of your
He should have,
ineffectiveness.
I mean, I've been in Quincy District Court before, and I've had hearing problems with clients I've had clients who've had problems with hearing, and they have apparatuses that they could, hearing, what do they call
Counselor,
them, headphones.
I didn't see an affidavit from trial counsel.
You're right, there isn't any, and unfortunately, he did not provide one. I contacted him several times requiring it. I think my affidavit I don't have it
I didn't
with
see an
me.
affidavit by you in your appendix, which doesn't mean there isn't one.
Pardon me?
Did you file an affidavit explaining why you didn't have the affidavit from trial counsel?
I usually do with the 30B motion. I don't know, I don't have the appendix with me. But I usually do, and I usually try to contact the trial court, the trial attorney several times. And I remember that he did not contact me, even though I asked him several times, I believe. And that's something that happens rarely, but it does happen with a 30B motion, in my experience.
Counsel, with that, as a follow-up, the judge based on the affidavit of the defendant, clearly made a credibility determination. He said that the defendant could hear because he remembers the defendant being animated when he heard some of the testimony. So without trial counsel's affidavit saying that that's not accurate, why isn't the credibility determination based on the affidavit alone, that the defendant did hear?
Well, as my sister pointed out, that it's quite clear that you have to give deference to the trial court in his memory. There's no question about it, and I'm not questioning the trial judge. He has a great reputation down in Quincy Court. There's no question about that. But the issue is how much weight to give the trial court. You have to give him deference, certainly. But when you look at the transcript, that there was nothing. There was nothing in the transcript, pardon me, there was nothing in the transcript that said that he admonished the defendant for speaking out of turn, for creating a problem. There's nothing in the transcript to say that there was any confusion or any type of noise or anything like that. So there's nothing in the transcript that says, that validates the trial judge's memory, and I'm not disputing that he has that memory. That's quite clear. Quite frankly, if he didn't write that on the motion, I think this would have been a layup. But he did what he did, and I can't fault him for that. That's his memory, because he did say that to me in court. So, but the point though is that more importantly, there's an affidavit from the hearing expert who has dealt with Mr. Horsley for 18 years, and there is quite clear that from Mr. Horsley's affidavit, though of course it might be self-serving, as my sister has pointed out, I think that we can sort of give him credibility that his bone had crushed his eardrum, and that remember also that so that expert's opinion, I think, overshadows the memory of the judge.
Well,
the only other explanation.
Let me ask you this. Do you believe that we can take the expert's affidavit to say that even if the defendant heard some things during the trial, there is no way he heard the entire trial?
I think that you could do that, because I think that the standard is not that whether he could hear some of this stuff. The standard under Commonwealth versus Elliott is that hearing impaired, let me see if I can get the quote for you. Statutory requirements and due process state that hearing impaired persons entitled to hearing accommodations. That's quite standard. Also, Commonwealth versus Elliott is that some notice has to be made to the judge. Notice was made to the judge. Whether or not it was adequate or not, that goes to whether or not there was.
Counsel, the problem I have with that argument is the judge has to be put on notice. And I know you're arguing ineffective assistance, but it seems to me a follow-up to not only does the judge have to have notice, but trial counsel has to have notice that there's this terrible hearing problem that the defendant has, that he can't hear everything. And I don't know how we can make a finding that the trial lawyer was on notice of that. Again, I know you have your client's affidavit, but on the record, what can we point to say that trial counsel knew that the defendant's hearing loss was so bad that he couldn't hear certain things during the trial?
Well, I think that there should have been, it's my opinion, or it's my argument, I should say, not to get too high and mighty, that's my argument that prior to the impanelment, he said, the judge, I think the attorney said that he has a hearing. Then the judge should have made some type of inquiry about whether or not this would be adequate. I myself think that, well, I would argue again that if he appears in his chambers, in the attorney's chambers, and he told him that he doesn't have a hearing aid, I would think that that requires a certain amount, a level of inquiry that's beyond the, now, if he didn't do that, if he did do that, he would have found that my client had this horrible impairment. Well, I shouldn't say horrible, but great impairment. And that he should have let the judge know that prior to the trial. I mean, he keeps on, he says it twice, and the judge knows that, well, people have to speak up. I also would point out to you that my client has ability to lip read, and that he, I'm sure that living with this, the alleged victim for a couple of years, she knew how to pronounce words that he would have no mistake, would not be mistaken about it. And so that could have been the animation that the judge was talking about. Further, that he has fluctuation in hearing that is known by the judge, not by the judge, sorry, that is said in the expert's affidavit. And so he may have heard some of the stuff, some of the things that he said, but of course, that's not Commonwealth versus Elliott standard. Then you have Commonwealth versus Carrion, that it becomes, once they're known, the judge has an obligation to make sure that, to make an inquiry to whether or not the defendant has an ability to comprehend and participate with his attorney. So I would suggest that there was structural error in this trial, that timely objection, presence is not enough. You have to be able to be informed about the proceedings. And I would suggest to you that this is not the case here, that there is a structural error in this trial and that my client's rights were deprived. And if we,
I just would ask you for something. We've got two affidavits by your client, and we've got the affidavit of the doctor and the motion to add the doctor's affidavit. But we don't have either of the new trial motions, and if there was an affidavit that you wrote about trial counsel, we don't have that either. I was hoping you could collect at least the motions, and if there's an affidavit we're missing, and give it to us as a supplemental appendix.
of course, certainly, any deficit I'd be more than happy to help you with.
Great.
Can we ask you to do that within the next 5 days?
Of course.
Great.
I'll probably get it out
Or
to you
sooner.
tonight, this afternoon. Tomorrow, probably. Is there any, if there's no other questions, I'll retire. I'll rest on my brief.
See no further
you,
questions. Thank you for your argument.
Again, thank you for your accommodations.
Good morning, Attorney Kelly.
Good morning. May it please the court, Tracy Kelly for the Commonwealth. I am asking this court to affirm the defendant's conviction because the judge did not abuse his discretion in denying the defendant's motion for new trial, and the defendant's claim on direct appeal is without merit. So looking first at the motion for new trial, the motion judge in this matter was also the trial judge during the defendant's trial, and he's afforded special deference by this court for the findings that he makes, as well as for his own observations regarding the defendant's hearing abilities.
Counsel, can I ask you about the observations?
Yes.
Would you agree that if a defendant cannot hear even certain portions of trial testimony, not all the trial testimony, but certain portions of the trial testimony, because he's hearing impaired, that would be a structural error?
I would not agree with that. Structural error has only been found in limited circumstances, including the denial of counsel, the right to a public trial, omission of an instruction on reasonable doubt, racial discrimination in jury selection, and trial before a biased judge. Since this does not fall in with that small class of cases.
I don't think we should make a new class here where if we find, and I'm not even remotely saying we're finding it, but if we found, based on the record and the affidavit, that the defendant could not hear certain portions of the trial, you don't think that's a new class of structural error? I mean, the defendant can't hear what's going on.
I would suggest that in this case, the defendant could hear what was going on, so I don't think that is relevant here. And currently, the case law that we have does not include that. As far as the defendant here saying that he was unable to hear, this was also not a preserved constitutional error, so he would need to show a substantial miscarriage, a substantial miscarriage of justice, and he doesn't, a substantial risk of a miscarriage of justice, excuse me, and he does not show that either. He doesn't raise any sort of error here. The record before us during his arraignment at the trial, the arraignment, the transcript reflects the first thing he was asked was, "Can you hear me, sir?" And he says yes. During the trial, there were only 2 instances where he said, "I can't hear," and both times it was immediately addressed. Throughout the trial, the judge reminded people to keep their voices up. He was proactive. There was no indication that the defendant could not hear after those reminders were made or after he'd said, "I can't hear." In addition,
It certainly seems surprised at the conclusion of the trial as to what had happened. The defendant.
I don't think that indicates that he was unable to hear. I think that it's possible to just, as a defendant, perhaps not be happy with the verdict when it returns.
That's certainly a possibility, but given the allegations in this case, that he says there was portions of the trial that he could not understand because he could not hear, given the affidavit that's not unusual because given his situation, there can be fluctuations in hearing as described by the defendant's counsel today. What are we supposed to do with that? I mean, it could really go either way.
I would suggest that the record before us does not demonstrate or prove that he was unable to hear. I think it supports the judge's findings that he was engaged with the trial. He was animated when he was hearing things he did not like from the witness. He was shaking his head, from the victim. He was
This brings up a point. Let me ask you this. Let's just say, of course, we agree that the judge, of course, can rely on his or her own observations, and it seems there was that there was a recall of this particular trial, already extraordinary given the amount of trials that are conducted in the district court. But is it fair to say that in this situation, the judge was not aware of the depth of the hearing loss problem, certainly was not aware of any information regarding a medical diagnosis regarding the hearing problem? Is that fair to say? I mean, all that was said to the judge was, my client is hard of hearing.
Right.
So speak up, which we do hear all the time, for example.
Correct.
Right?
I think, though, from this, the defense attorney did tell the judge that he was hard of hearing. The judge then said, "I will keep my voice up and ask others to keep their voice up as well." And the defense attorney said something along the lines of, "Okay," in response. There was nothing to indicate that that was an insufficient remedy.
I agree. There was nothing, I'm sorry to interrupt,
Right.
nothing on the record. And exactly that was a question I asked the opposing counsel here. But it is true, it is fair to say that the judge was not aware of the actual diagnosis, let's put it that way, or all the contours, so to speak, of the hearing loss. He just was told that the defendant was hard of hearing. That's it.
I would say, though, that we are not aware of the extent of the defendant's hearing inability, alleged hearing inabilities at the time of the trial, though. It is the defendant's burden to prove that, and he really hasn't. He offered these 2 affidavits where he states without support that he was unable to hear at that time. He says that he didn't have his hearing aids. He does not provide any support to indicate whether or not he was without his hearing aids for the 1.5 years this case went on for. He did speak to the court in at least the arraignment we have the transcript of and the trial. He also, looking at the affidavit from his audiologist, that report was made a year after the trial. That report does not indicate the defendant's hearing at the time of trial, so it does not support that at the time of trial
Well,
this
the
was
doctor
his...
says during those years, and he's been his doctor for a very long time. I'm not sure how you're discerning from that the hearing loss just came up recently.
I would suggest that he did not provide a report from his doctor he's been seeing for years of his hearing at the time of trial. This report reflects his hearing a year after trial and not at the time of the trial.
From my examination of Mr. Horsley during those 18 years, I've concluded Mr. Horsley has profound hearing loss in his left ear and severe hearing loss in his right ear. I mean, don't we have to understand that as the hearing loss going quite some time?
I would suggest he should have provided a report that demonstrates his hearing abilities or inabilities at the time of the trial from his doctor he's been seeing for these 18 years. And I would also point out that the defendant's doctor states that he could have fluctuations in hearing and that his hearing could also be, the defendant would be able to hear with the use of a hearing aid or any mechanism that enhances the ability to hear.
Well, he wrote, I am not aware that his hearing ability fluctuated, but it is possible.
Correct.
Not quite the same as saying that he discerned there were fluctuations.
But I agree with that statement, but he doesn't rule out that there are fluctuations. He says it could be, but again, the affidavit does not state this is his hearing inabilities at the time of the trial. It also indicates that mechanisms to amplify hearing could be and would be sufficient.
This just seems like good stuff for an evidentiary hearing.
Yep.
Doesn't it? I mean, these are the kind of things that could be explored in an evidentiary hearing.
They could be. However, an evidentiary hearing was not required here because the judge did not find that there was a substantial issue raised. And he clearly stated in his findings that he remembered the trial, he believed the defendant could hear, the defendant was animated when the victim testified, he would shake his head, gesticulate wildly, react when people were speaking, that he didn't agree with their statements during the trial, and that he did not believe the defendant's affidavit, and therefore an evidentiary hearing was not required.
Is it at all significant, I just had to quickly look through the trial transcript, that no one else in the courtroom seems to have had any issue hearing people except for the defendant? Doesn't that give credence to the defendant's affidavit? For example, there was one part where the officer's testifying and the defendant just sort of blurts out, I can't hear, I can't hear. No one else says that during the transcript, like, can somebody raise their voice? I can't hear. Doesn't that lend credence to the fact that he was having trouble hearing witnesses' testimony? I mean, for example, if I'm a trial counsel and I have trouble hearing a witness, the first thing you do is, Judge, can you ask him to raise his voice? I'm having trouble hearing. The prosecutor doesn't do that. The defense lawyer doesn't do that. The judge doesn't do that. The only one who does that twice is the defendant.
I think, though, the fact that he only does it twice demonstrates that he was able to hear throughout the rest of the trial. If he felt comfortable, and he did speak out at those two occasions where he said he couldn't hear, and had he continued to be unable to hear, he would have continued to voice that he was unable to hear, and these situations were remedied. The witness was asked to speak up, and the judge repeated himself, and there was no further complaints from the defendant that he was unable to hear. Again, though, this is the defendant's burden to show that he truly could not hear, and the record does not support that. The record has these two instances, and there were no further commentary or requests to speak or that he couldn't hear or for additional intervention to assist in his hearing. If there are no further questions, the Commonwealth rests on its brief.
Right, I see no further questions, but just for the record, I don't believe I called the number of the case when the two of you got up, and so it was this, we just heard case number 2023-1197, Commonwealth versus Raymond Horsley. Just want to make sure that was clear for the record. Thank you both very much for your arguments and your briefs, which are very helpful. We'll take the case under advisement. And you're going to get a supplemental appendix to us within 5 days, correct?
Yes, I will.
Wonderful.
Thank you.
Thank you both very much.
Good job.
Thank you.
Okay, the next case on our list, give council a moment to gather their things, is case number 2025-0435. I may need some help pronouncing some of the names of the parties in this case, as well as the lawyers. But we have Juul LLC versus Shangwa, or known as K2 Medical LLC, and others. Good morning.
Morning, Your Honor.
Is the name of your client Juul, is that correct?
That's correct, Your
As
Honor.
in Juliana? Juul? Okay, thank you.
Good morning. My name is Mike Gillerin. I am the counsel for Juul in this case, who is the plaintiff and appellant. We are here today on Juul's appeal of a judgment in the trial court against Juul's claims under the Massachusetts Uniform Securities Act, or MUSA, as I will refer to it, and Chapter 93A. Juul says this judgment below is erroneous because, as to MUSA, it violates the fundamental principle of MUSA of seller beware, not buyer beware, as established by the SJC in the governing case of Merrim versus Kobrick. In violating the fundamental principle of MUSA of seller beware, the trial court erroneously applied MUSA to Juul's 4 separate grounds for a MUSA violation, all based on appellee's material omissions in the sale of a security to Juul. Likewise, the trial court's judgment erroneously held that Juul's 93A claim, where material omissions held against Juul's 93A claim, where material omissions also constitute a violation.
So let's talk about those material omissions.
I'm sorry, I can't hear
Let's
you.
talk about the material omissions for a minute. And we'll start with the baseline that, as you argue, and as you are supported by the case in Merrim versus Kobrick Offshore Fund, which is that your client, as the investor, right, had no obligation to do any independent research, right? That's one of your
So I didn't hear that. My obligation to do what?
independent research or look into any information that was
Correct, Your Honor. That's
okay.
exactly right.
All right. So in this case, your point is that it was a material omission on
Yes.
the part of the defendants not to tell your client the financial situation that GTI was in at the time he gave the $64,000. We'll call it a loan or payment or whatever, however we want to call it, right? Now, of course, the judge disagrees with that and says, the website was provided, and in the actual email that was sent to your client, which is the email that's dated on June 9th, which seems to play quite a role with at the transcript and in your case, says flat out, Paul, to your client, here is a deal that perhaps you can assist on, but it has a short fuse. Check the website for GTI Inc. What was the explanation at trial about what that meant, a short fuse? Was there any?
Yes, Your Honor. It's on that exact same email. Later on the page, it says, we need the money by July 28th. That's the short fuse. That's all there is. It's the timing and nothing else.
Nothing to do with the financial?
It has nothing to do with financial statements or anything of that nature. It's on the page. You can read it
No,
on the email.
I read the whole page. I just wanted to be sure that was what your position was.
That's all it is. It's nothing about, look at the financials or anything like that. I mean, Merrim versus Kobrick is clear. It is governing law. And it says, all that is required is ignorance of the untruth or omission. That's it.
Well,
They've got to show.
But he's not ignorant.
He's got to read the disclosures he's given, right?
Sorry?
If he's given a disclosure, he has to read it, right?
He has to read it, if he's given a disclosure, of course. But the rule then is, as The SJC in Merrim cites the leading treatise in the blue sky law area of J.C. Long called Blue Sky. And it says here, taking the SJC's principle of all that is required is ignorance, and says, only an investor's actual knowledge is relevant. That's it. Go look here, go look there. He's sophisticated, imputed knowledge, this, that, the other thing. None of that matters. The SJC has said clearly in Merrim, none of that
Again,
matters.
if you
only actual
Hold on,
knowledge.
you give a disclosure to someone, the fact that if you give someone a disclosure, here's the disclosure,
You give 'em a
and
disclosure.
the guy says it doesn't read it, his ignorance does matter, right?
If you give them a disclosure that responds to what was previously offered, the 401I2 of the BUSA says that an offer defines what an offer is. An offer is any attempt to dispose of a security, and then to revoke an offer, you've got to do the same thing. You've got to make something very clear to someone that we revoked an offer. So if there is a disclosure of some kind somewhere, it's got to make it clear as to what it's doing. It can't just be a blank.
Well, this says check the website.
It's a check the website.
Check the website. In the very
Right.
first line, okay, check the website. And I guess what I'm understanding you to say is that when your client testified at trial and said, I didn't bother to check the website.
That's correct.
Or read the subscription agreement that came later on, et cetera, that he wasn't, your point is he wasn't required to, right? And your point is that that was not, even more importantly, I understand your point to be that telling him to check the website was not a sufficient disclosure.
There's no disclosure,
So
Your
what
Honor.
more would you
It's
want?
nothing.
What if it said, check the website for GTI's financial predicament? That would have been okay?
That's not enough. It's got to, the SJC has said, in the treatises say, it's actual knowledge. Go check the
But
website.
that's
check
why I
this,
keep,
that.
that's why I
None of
keep,
that
that's why I
matters.
keep
Hold
asking
on.
this question, because you keep saying actual knowledge matters, but then you tell me that you have to read the disclosures. So if someone gets a disclosure and doesn't read it, they wouldn't have actual knowledge. But would that make the claim? Would you have the claim if you just, someone said, here's the disclosure, read it, and you said, I'm not going to read it, do you then have a MUSA claim?
That would be different. I mean, an actual disclosure that you're given, yes, but to go check someplace else, that's.
So what if you say, here's the disclosure, click this link, and you'll get the disclosure? Would that be enough?
That's not, under the rule of, the rule of Merrim must be changed.
One
for
more-
your
one more-
situation
one
to
more
result
example.
in non-liability. That won't work.
Let me follow up with Justice Ditkoff's example with what if the disclosure is attached to this email and your client says, I never read it?
That wouldn't work.
That's no actual knowledge.
If you're presented with it, you can't disclaim, you can't disclaim knowledge of something.
What if it's a
that's in front of your
PDF,
face.
you have to double click?
Exactly.
What if it's a PDF, you have to double click? You know, you do the offer and you attach this disclosure. It says disclosure.pdf.
I
You
am
have to
sorry.
double click it to read it. Is that,
Repeat myself, which is that the SJC says that's not enough, not enough. It's not enough. It's actual knowledge. That's what it is. That's the rule.
So ignorance is a defense?
Yes,
saying that's what the
ignorance is a
SJC
defense if you're
is
not
saying.
directly presented with it. The other side argues that he was willfully ignorant, therefore he's liable. No, he didn't know. There's no test of willful ignorance. There's no test of if he should have done.
I think what the other side is saying is that they didn't materially omit they didn't make any material omissions.
Pardon?
I think what the other side is saying, what the judge found, was that there were no material omissions.
It was due to knowledge that was either imputed to him because he was sophisticated, or he could have gone someplace else, or he could have verified it. The judge
I'll give you this, that the judge does indicate in his findings that your client is sophisticated. And we can all agree, he appears to be a very successful, sophisticated individual as far as we can tell from the trial. But that doesn't matter. That's true that, as you cite in the Merrim case, the sophistication of the investor is not a factor. But the judge didn't really hang his hat on that particular finding in rendering his conclusion in this case, right? He basically his conclusion was that there was no material omission, basically because
that's not correct, Your Honor.
No.
There's no argument that the material that my client didn't know was not material. The judge did not conclude that the material he didn't learn about was not material. We argued it was material. There was no finding it's not material. The other side never even argued it wasn't
Let me
material.
clarify that there was no omission.
Sorry?
That there was no omission.
They also agree that my client was not told about the dire financial condition. He wasn't told that his rights were not individual to him.
Well, the judge specifically found that he knew that GTI needed to raise $1 million immediately. And I know your client doesn't agree. He maintained that he didn't know that, but the judge, on a credibility determination, found otherwise.
That's as to the one about his individual rights. And if you...
But doesn't it go to both of them?
Yeah.
I mean, this is a biotech startup, so of course it's not going to have money and it's going to have debts. And if your client knows that in addition it needs $1 million before it can do anything, to say I didn't realize that it had lots of debts and no assets, that would be material to the decision.
I've got
Doesn't
two
really
questions
ring
here,
true.
and I want to answer both of them. But I'll take yours, Your Honor, first. That one is a different case. There, at least, there was testimony at trial that, in spite of all the documents we sent you, and all the writings and all the context and everything else, we told you that there was a condition on repayment, which is the $1 million raise. And there, if you look at, and we ask you to do this, to look at all the context, which was the Shangwa was broke. They tried all the options they had. They only had a few weeks left. They tried all their other board. They have nothing. They had one place to go, and they went to Mr. Conti, and they touted this and touted this and touted this to him. It's the best deal going. Everyone else believes they're going to get paid. And then they even admitted this was a big and salient point, this issue of the $1 million condition. But if you look at the documents, the emails, it's not there.
Well,
It's empty.
it is in your own client's email saying that was his understanding.
That was years later after he was told by them.
Okay. The judge decided otherwise, and you would agree that we have to accept the judge's findings, correct? Unless they're clearly erroneous. Unless they're clearly erroneous.
Based upon a subsidiary finding that my client didn't know. There's no such subsidiary finding and no fact even alleged that my client knew about this $1 million condition. It's not even there. What he relies upon principally in that argument is my client should have known because he's sophisticated, but none of that is allowed by Merrim or under MUSA. For that to be allowed, MUSA must be changed, Merrim must be overturned, the treatises must be changed, the whole law of MUSA must be something different than what it is right now. You've heard my argument. What we're asking for is on the record as it stands.
Okay.
The record as it stands, my client, all of the material omissions were material. It's not disputed. As to 3 of the 4, my client did not know except for this one finding that he knew where there's no subsidiary finding at all. And based upon that record, his lack of actual knowledge, my client is entitled without even analysis to prevail. Is entitled as a matter of law to prevail. And once that's so, this case should be reversed, both as to MUSA and 93A, which also provides for liability for material omissions reversed, remanded.
I just want to back you up for a moment. I think I heard you say just a moment ago that the judge did not find that your client knew about the $1 million funding that was
He did on
conditioned.
that one. Judge said my client knew that one.
Okay, all right. The
That
judge
one.
did find that. Okay, so
That-
unless
there are-
just
Yes,
let me
there
finish.
are-
Please let me finish. So unless we were to determine that finding is clearly erroneous, we would be bound by it, correct?
No, that's not correct. Under the standard of where there is a clear conviction of mistake, this court is not bound by that finding below, Your Honor. Clear conviction of mistake. And again, the clear conviction is everything supports my client's view.
Let me back up. When you say clear conviction of a mistake, do you mean a mistake between the parties?
No, of the trial court below.
So whether or not the fact is clearly erroneous?
The only thing that supports that conclusion is Mr. Antonopoulos' testimony.
And your own client's email saying
Several
that's-
years later, yes.
That's what was promised to me at the time of my investment into the same. why is it clear error for the judge to believe your own client's written statement?
They weren't going to give him any money. They told him, we're not going to give you any money. In order to get something out of them, he says, several years later, yeah, okay, raise your $1 million and give me some money. But that's several years after the fact. There's nothing at the time, other than Mr. Antonopoulos' testimony, which is contrary to all of the documents.
Okay, we understand your point there. I'd like to ask you quickly, before your time is up, about what it is your client is looking for. At the time, he also argued that he should have been able to convert his investment, I'll call it an investment, $64,000, into GTI stock. Is that right? That was one of the allegations he made in his complaint?
If I understood you correctly, the right to convert should have been his. That's what he was told in the emails directly.
And in his complaint, he mentions that. At testimony at trial, he says that that was converted without his knowledge and should not have been. Correct?
I'm not sure if I understood that question, Your Honor.
He says at trial that his investment, I'm going to call it an investment, the $64,000 check that he wrote, was converted to GTI stock by Shangwa, by the managers, without his knowledge. That was his
Yes, that's
position.
correct.
Okay.
Anyway, I thought he doesn't have any stock in GTI.
That was my question.
He's got ownership units in SHENGHUO, and his complaint was that SHENGHUO converted its debt into stock of GTI.
Well, actually, he converted his debt into stock. Actually, it took place in 2020, which was 4 years later, and he didn't, I don't know the exact timing of when he learned that, but it took place 4.5 years after the.
But he says in his complaint that is the issue, that he was entitled to have his investment converted into GTI stock. That's in his complaint.
I don't recall what the complaint said, Your Honor.
So right now, that's not what he's looking for. He's looking for a repayment of his $64,000 plus interest as calculated in the original June 9th, I think it was, email. Is that right? And attorney's fees and other damages that might be attended to 93A. Is that fair to say?
Yes, Your Honor. And so remand is, of course, interest, attorney fees under both MUSA and 93A, whether there's double damages under 93A and joint and several liability.
But he's not looking for any ownership in GTI.
Sorry?
He's not looking for any ownership in any stock in GTI.
No.
Okay,
No,
just
Your
wanted to be clear about that. Thank you.
Thank
Any
you.
other questions? So I took up most of the time, panel members? No? Okay. Thank you very much. All right. Good morning. Is it Attorney Amade? Am I pronouncing it correctly? How do you pronounce your name?
Yes, Your Honor. It's
Thank you.
Attorney Amade.
Amade. Okay. Good morning.
Morning. Good morning, members of the panel. May it please the court. My name is Hannah Amade, and with me is Attorney Suzanne Elavecki for the appellees SHENGHUO Medical, Richard Blumberg, Michael Antonopoulos, and Mark Faupel. Your Honors, JUUL frames the issues on appeal as legal questions about the materiality standard. But what it is really asking this court to do is what appellate courts cannot do. And that is, after a bench trial, second-guess a trial judge's credibility determinations. JUUL is asking this court to reweigh the testimony and documentary evidence and substitute your judgment for the trial court's, which is precisely what the clearly erroneous standard forbids. The trial court found, based on both witness testimony and documentary evidence, that my clients disclosed all material facts before JUUL's investment.
Let me ask you about that, and this is a follow-up to opposing counsel. The SJC in Merrim was relying on the 10th Circuit Mid-American case. And in Mid-American, it clearly says that an omission by a party doesn't get fixed by sending information to the investor if the investor doesn't read it. So the judge never made a finding below that the investor read it or knew about it. What he made the finding is that he should have known about it and you guys sent it to him. I don't think there's really a dispute about that. So how do we get around Mid-American's language, which I might not agree with, by the way, but.
Your Honor, what the trial court found was that there was no omission of the material facts. The trial court found that based upon the testimony and documents at trial that there was a full disclosure of GTI's financial condition on GTI's website. The duty to investigate argument provided by my brother is misplaced here. The full statement of the law from Mid-America Federal Savings and Loan Association versus Shearson is that a purchaser has no duty to investigate a seller's possible fraud and need not verify a statement's accuracy. But this is not the argument that GIUL is making here. GIUL's argument is essentially that there's no duty to investigate, period. Even though the link to the website was given, GIUL argues that Musa does not require him to click the link or...
Here's what I don't get. That email says, if you look at the Guided Therapeutics website, you will readily can see the integrity of this device. It doesn't say, if you click on that link, you'll find out the financial condition of GTI. I can see why that's a disclosure of what the website says about the integrity of the device, but to suggest that that meant you had to go look at all the filings that the judge relies on, I'm not getting how that's a disclosure of those things.
The trial court did note in its findings of facts and conclusions of law that when a public company discloses serious financial problems in its SEC filings, that no reasonable investor could have been misled into believing the company's financial health was sound. And
That's true, but the judge did make clear, just to follow up and make sure we're all on the same page, that the reason why there is no material omission in this case is because this email that Justice Ditkoff is just referring to says, check the website. It's unequivocally established at trial that GIUL never checked the website, right? That never happened. There was no other testimony, if I recall, please correct me if I'm wrong, from your clients that said, oh yeah, before we got the $64,000, we said this company's in dire straits. That wasn't the case, right? All they did was say, check the website. Am I right about that?
Your Honor, they also did disclose the condition of requiring
of $1 million. Yep, got that. And they may be intertwined, as already mentioned by Justice Ditkoff. But that's it, right? The only information regarding the financial dire straits of GTI was in this particular email saying check the website.
Yes, Your Honor, but...
Just want to be sure that's the case. So really, it all comes down to that, doesn't it?
The fact here, though, Your Honor, is that there was no omission. The sufficiency of whether or not check the website isn't challenged here. It's whether or not GIUL proved an essential element of its case.
But if we were to say checking the website is not sufficient to alert anyone to GTI's financial situation, and that was material, we would decide that was material to anyone's decision to make the investment, well then, that becomes the operative finding there, right? And that's all we have.
Your Honor, respectfully, going back again to what the trial court noted, that when a public company does make the disclosure of their serious financial problems in these public SEC filings, there's no reasonable investor could have been misled into believing that the company's financial health was sound.
I'm even going to say that makes perfect sense to one member of the panel here. That makes perfect sense, but that's not how I read the case law. It's particularly the case law that Justice D'Angelo, the comment that he just read to us. And we're bound, we're bound by two things: the judge's findings, which are in your favor, and the law, which is we have to interpret, but we're bound by it. So that's where I see the defendant's biggest challenge.
Yes, Your Honor. I think that what I would like, or what I'd suggest is that by not clicking the website link that was provided to Mr. Conti made a choice. This was not an omission.
But I don't know why that choice matters. If he had clicked on that link and looked up the integrity of the device, as he was told to, he still wouldn't have learned anything about the financial condition of GTI. So why does it matter whether he did that, whether he did what he was asked to do or not?
Your Honor, at the end of the day, what this is this argument, what it would mean is that if a buyer could simply argue an omission by the seller by using the buyer's own refusal to read the disclosure made by the seller, that is.
No, I get, that was the argument your friend was making, but the disclosure here isn't, click this and read about the financial condition. It says, click this to see the integrity of the device. I don't know why that's a disclosure of the financial condition of GTI.
The disclosure itself is on the website. So it's.
What do you mean? Like, if you clicked the GTI website back then, it said financial condition is terrible?
I believe that there was a link
Come to
provided
Judge
for
Fry.
the investors, which is a standard public company.
And then you could link on to the SEC filings, the 10K. You could keep going, but that required some investigation, which our case law says you don't have to do.
But the investigation, again, goes to investigating a seller's possible fraud or not needing to verify statements' accuracy. In this case, the duty to investigate is really almost a red herring.
I see your point. You're saying that duty to investigate only involves other categories of factors that one might be considering, but not this.
Exactly.
Well, what do you say about the end of that email when there's an encouragement to make this for Mr. Conte to make this investment by saying that it's a winner, and the lender is so covered, referring, of course, to the fairly favorable terms of the repayment of the loan. Correct?
Yes.
Let's discuss further.
I think what that speaks to, Your Honor, is my client's optimism about GTI's success, about my client's optimism about the ability for the investors to be repaid should this condition be met. I think that's exactly what it goes to.
So I understand GTI at trial anyway, the indication was that it had become quite profitable.
Yes, Your Honor.
I have to ask, and there was no conversations in terms of taking care of this case outside of litigation and outside of coming here?
Not since before trial.
Okay. I guess it all depends on how lucrative and how well GTI is doing these days.
And Your Honor, I see that I'm running short on time, so I'll just
Sure.
briefly close. Your Honors, in conclusion, the trial court watched our witnesses testify, assessed credibility, weighed the evidence, and these determinations are afforded deference. The trial court made sound factual findings. GIUL may disagree with them, but GIUL's disagreement is not a basis for finding clear error, and the judgment of the trial court should be affirmed. Thank you.
Thank you very much. Let me just see questions. No questions. Thank you very much. Morning, Mr. Green. Attorney Green.
Good morning, and may it please the court. My name is Matthew Green, and I represent Mark Pearlstein. I think the most important thing here is to reframe the argument here as it pertains to my client. All of the questions that have been posed, all the argument that has been posed has nothing to do with Mark Pearlstein, who during the operative times was operating as general counsel to the company. I think the most important thing to do here is acknowledge the waiver issue. If you read my brother's brief, if you read our opposition, if you read his reply, and frankly his 15 minutes of argument, nothing pertaining to my client was ever mentioned. It's undisputed that my client was not a managing member at the time in June and July of 2016 when these solicitations were made. There's no wrestling in either the briefs or the argument with control person liability versus primary liability under MUSA as it pertains to my client. These are really dead letter issues. The court found that he had liability under neither. I would say where there is no argument as to my client, as to why he would be liable or to disturb those findings, these issues are waived, and regardless of what happens with the rest of the case, the judgment needs to be affirmed against as to my client. Since there's no argument to push back upon, I'm happy to answer any questions that the panel have, but I don't want to belabor this with just repeating what's in my brief.
Okay, any additional questions? Actually, no, I'd like to commend both of your colleagues here for answering all of our questions thoroughly. We appreciate it. We certainly pressed you both. That's our job. So you shouldn't take anything from that other than the fact that we want to get to the bottom of everything. And we appreciate your offer, and we're not going to take you up on it. So thank you very much.
I appreciate it. Thank you all.
Take the case under advisement.
Thank you very much.
All right, thank you. The next case is 2025-0979, the Department of Children and Families versus Child and Another. And of course, this case is impounded, as the attorneys well know, and remind the panel members of that as well, so we won't be using any names. Just a moment, please.
Oh,
All right, I think we're ready to go. Good morning, Counselor.
Good morning, Your Honors. May it please the Court, Attorney Gary O'Brien on behalf of the appellant father, and I'm splitting my time with counsel for the appellant child with regard to the case. We're here before the Court respectfully requesting that this Court remand the case back to the trial court for a new trial, basically on the premise that the trial court erred in finding that father was unfit with regard to this case. It's a permanent custody order. It's not a termination of parental rights. But nevertheless, we're here with regard to that decision, basically to request that that finding of father's unfitness was error. And specifically, when the trial court was focusing on father's unfitness, really kind of lumped in mother's unfitness, substance abuse, which was, there was some, there wasn't really a showing of nexus between mother's substance abuse and harm to the child, but with regard to the father, it was really phrased as father's failure to have insight into mother's substance abuse and how it affected the child, which is kind of a hard standard to be able to determine. The second issue was with regard to housing. I think in our brief, we kind of lay out the issues on page 12 or 13 of our brief with regard to father's fitness and why DCF basically said that it had no concerns with regard to the father, that father had done what they had asked him to do.
Well, he's in a house where we don't know whether there's an appropriate bedroom, where the social worker's never been able to see, and where there's a level 3 sex offender living. So how could he be found currently fit? How could the child be given to him at that point?
Well, Judge, I think as we cite in our brief, if you look at care and protection of Elaine and some of the other casework, that homelessness by itself is not necessarily the enough to find unfitness. One of the things in Elaine specifically, it talked about the department using under Chapter 119, Section 1, all services and efforts to kind of help the father to obtain housing. And there really wasn't much effort other than trying to refer to websites and to get on lists with regard to housing. It really goes to, in terms...
Was the issues of best efforts brought up in the trial court or litigated in any way?
In terms of reasonable efforts, it was not, Judge, to be fair, in the record. I think in the terms of a finding of unfitness, it nevertheless, you're looking at the issue of finding unfitness, and that all gets put together in terms of is homelessness enough, is mother's substance abuse enough separate and apart to find father unfit. So I think that reasonable efforts wasn't per se involved, but under care and protection of Elaine, that court looked at the case and said, you know, father's issue of not having proper housing wasn't enough to find him unfit at that point, and it really was up to the department to try to work further to try and assist him with regard to finding housing.
What's the department supposed to do when the father's position is He hasn't done anything to find housing in 18 months because he's working, so mom has to do that. And his plan is to stay in the house he's in. I mean, what is DCF supposed to do in that situation?
Well, I think they were kind of providing him with list of housing and kind of looking at opportunities to do that, but there really wasn't any assisting with regard to him. I'd also point out that
But if they're giving him lists and he's doing nothing, that's what he testifies. Nothing. I'm not doing nothing. I haven't done anything in 18 months. Then what's the point of doing additional efforts when his position is the stuff you've given me, I decide to do nothing at all with?
I'm not sure that that's exactly the testimony but I think in terms of the housing issue, it's also
What have you done to
important
try to
that it's
secure housing in the last 18 months? I'm not really able to because of work. Did you assist mother in trying to obtain an apartment? No.
Okay.
Is there some other way to read that?
Well, fair enough. I think one of the other issues is that it's, again, going back to that the housing isn't sufficient enough to find unfitness, even if in terms of what Your Honor has pointed out. But there's also the issue of poverty and how that affects the determination of neglect. And so in terms of this case, if they're sitting there and saying, well, we're not going to go and able to move out where we can live right at this time, if there's a plan to kind of reunify our child to be back, then we can work toward trying to find housing. But to go out and spend what little funds we have to obtain housing but not be able to have our child returned to us because the department's not willing to do that, then I think that becomes the issue for the family. I guess the other points that we have were with regard to the trial court's focus on mother and the focus on the two other children who at the point of trial were no longer really involved. So the failure of the trial court to consider how father would parent just the one child without the burden of having to care for the other two children, that makes a significant difference as well. The final aspect of that is really with regard to the child and how she was suffering in care with regard to, I believe, 4 moves in terms of the pendency of the proceedings before trial. I think my appellant's child's counsel will go into that a little bit further. So I think that the child was doing well in school, was having issues in the placement, but voiced again and again that she wanted to be able to return to the care of her parents. But I think we've gone through pretty much our argument in terms of father's unfitness of it vis-a-vis versus the child separately and apart from the other two children and with regard to mother's issues. I don't know if there's any other questions, but then I'll refer to child's counsel.
One moment, and I'll check. All set.
Thank you.
Panel has no further questions. Thank you.
Thank you, Your Honor.
Good morning, Your Honors. May it please the Court. My name is Valerie Robin. I represent the child. My client's trial counsel is also virtually present and watching this via the Court's YouTube channel. Child is requesting that this Court vacate the decision and remand to the juvenile court for new trial to determine whether she may safely be returned to father and under what conditions, and if so, the reasonable time frame to do that. Today, the child is 10 years old and in the 4th grade. This appeal is about a child and her father and whether her best interests were considered in the context of father's fitness, where the court adopted DCF's approach to lump together father with mother's unfitness as to her other children.
The father, there was a plan in place for reunification, and the court found that the father did nothing to address any of the issues regarding reunification. So what do we do with that?
The first problem was the plan for reunification pitted father in the context of him being reunified with the other children that weren't his children. He was not the father, he was not married to the mother, and it considered issues in pitting that against the reunification in terms.
I don't know if that's 100% accurate. Part of the reunification was he was supposed to go into therapy and stay in therapy. He refused. Well, he tried, he did a few, and then he said, I don't know why I'm here, and he left. So that hadn't, I mean, I guess in some sense, the therapy had to do with all the children, but it also had to do with your client.
Well, first of all, I think what the record said with regards to father's therapy, and I represent the child, is that he went, and not unlike a lot of people who go to therapy, he didn't understand why he was in therapy, and the therapist released him. So I don't think that that's him refusing to go to therapy. And the second part of what's going on here was about father and child and the best interest of that.
How about the fact that I think it's pretty clear prior to trial, the child was having some educational and medical issues, and father did nothing about that. He basically said mother's in charge of that.
You mean prior to removal, Your Honor?
Yes.
Okay, just to be
Sorry.
clear. No, it's okay. Well, I think what is relevant was she wasn't having educational errors. This was a 6-year-old at the time of removal. In September of 2022, she was 6 years old and she was eligible for the first grade. She had an October birthday. So she didn't, the evidence was the judge said she was technically enrolled, but the kids didn't go to school, okay? She wasn't having any behavioral issue. She wasn't having any medical issues. There was no 51A reports from any of her
I don't get,
dentists.
but she's a 6-year-old who's not going to school at all.
Mm-hmm.
That seems like neglect right there, per se.
So a 6-year-old who's not going to school, the law provides that the parent is punished. It doesn't provide that the parent is
And we
unfit.
punish the parent, right, because they're unfit, they're not educating their child, right? It's not for some other reason, is it?
Well, there's a fine under the chapter. However, again, does that make the father unfit at the time of trial? Does that make the father, I mean, the child's going to school and doing well.
Right, well, so what? You have a situation where when the father was in charge, no education at all, and once DCF was involved, there was education. What in the record suggested that things had changed and the father would now take the child's education seriously?
Well, a lot of things suggested this is a father, unlike the other two fathers in this case, who was going to every visit. He was participating as much as he could in his plan as to the issues that affected the parent. And not once did this court or DCF ever consider what would happen to this child if father was in charge. Mother and father were not married, so mother had custodial rights by law. I mean, a lot of times in these cases, father goes over to probate court, but none of that ever happened. And in the end of the day, what I'm asking this court is to consider the fact. This was a case that started because the child wasn't in school and supposedly housing instability. The court found, I mean, the record was that they had moved from 2 different hotels. The court phrased it that they were jumping around from hotels. The court phrased that there was severe medical neglect, but the record really didn't that. The neglect was relative to the other 2 children that aren't part of this appeal. And in the end of the day—
There wasn't serious dental neglect with respect to your client?
Serious medical neglect?
Dental neglect?
Dental neglect was what the judge found, based on the following, where the pediatrician said she had bad hygiene. The pediatrician is a mandated reporter, never made a report. Again, we're trying to fit something in after the fact to this child, and at the end of the day, you have to consider the fact that the state hasn't protected, in this case, the state, her life isn't better right now. What happened? She's been at trial. By the time of trial, in 19 months, 4 different moves. 6 months into after DCF had custody, if you want to talk about neglect, now there's a behavioral diagnosis. The child had all these, the judge described this case as heartbreaking. The child was doing fine in school at the time of trial.
The child wasn't in school at removal.
No, at the time of trial.
Okay.
Because of DCF.
Well, then that's,
Because when she was with father, she wasn't, partly with father and mother, she wasn't going to school.
she hadn't gone to school in first grade. That is correct. I mean, that was what the evidence was. But there was nothing to suggest that she wouldn't continue to go to school in father's care. There was nothing to suggest that.
What suggested that was when she was in the care of father and mother, as Justice D'Angelo is pointing out, and Justice Ditkoff has mentioned, she wasn't going to school. So can't the judge look at that as
But I don't think that would have.
factor?
I think.
And also the fairly severe neglect of medical neglect, including the dental neglect and the gaining of weight and things like that. Can't the judge look at what was going on at that point in time?
I think to suggest the gaining of weight is.
Just weight gain, of course, no, but in this case, there was a
Weight
finding
problem.
that it was fairly serious.
Right, because.
Indicating a nutrition issue.
Well, in the 19 months, she gained also a lot of weight, that she was in DCF's custody. Is this a child who perhaps has a bit, and I don't want to get into a body type, I don't know, but I don't think that was really, I think the problem here, Justice Vuono, is that on the continuum, everything wasn't enough. And the judge said it, housing wasn't enough to do it. The report of the expert wasn't enough to do it. And then almost, which my brother and I both raised, but almost as an after effect, when you read the findings, look at footnote 1. After she wrote the decision, I suspect, she said, we got to put this in context because all the findings are about the 2 other children. And in terms of best interest for the child, just like the law says in adoption of Ramona is that it should be child-specific as to each child with each parent. It should also be parent-specific.
Your client's not going back to just the father. If your client goes back, going back to father and mother, right?
You're talking about going back after a remand of the trial?
No, I mean, father is with mother, at least was at the end of the trial, so there's no giving the child back just to father. He's going to be in a house with mother. She's going to be in a house with mother too, right?
That's correct, but also you have to put it in context, Your Honor, is that the court was able to put conditions. Father was working, which is amazing in these cases. The child was enrolled in school. At that point, when the child doesn't go to school, there's mechanisms in place that alert the child. You have to understand that certainly the child could be going to aftercare and before care.
Well, let's see, now you said that in your brief, but father was asked for a parenting plan repeatedly by the social worker and said he had written one and he just kept forgetting it. So when he's given, if he gave a parenting plan that said, here's what we're going to do after school, but instead just keep forgetting the parenting plan, how can you assume any of that stuff's going to happen?
My memory is not correct that as to the parenting plan. I do believe that there was issue as to a budget that the mother and father failed to. And again, I think you have to take this in context of what DCF is asking these parents to do, and also asking, if you really want to dig deeper, look at the action plan for this. This was all designed
Actually, they stated they had one, completed parenting plan, completed through their social worker, the private social worker they attained, asked them for the plan, and they still haven't, brought it into the department. They forgot it, but they'll remember it the next time. That's the parenting plan. Why?
Was that from the...
That's from the social worker's testimony.
Pardon me?
Social worker's testimony I was reading to you.
I was going to say, well, the issue... Again, the failure to support, I would argue the same thing about being able to housing. The failure to give a parenting plan did not make him unfit, and did not make it. I mean, there's a lot of things that are right in this case, and there's a lot of things that are wrong in this case. And I'm asking this court to look at this about what we can make right in this case. This case is about a parent and child, the father, notice the 2 that are appealing, the father and the child, not mother and not the 2 other children. And the record the facts are all about, primarily, I should say, primarily about how mother interacted with the two other children and as well, perhaps, with the younger one.
I guess that's where and I know your time is up, that's where I'm having trouble with the argument that you're making, which is mother was in charge and mother didn't do a good job. Father didn't do it. But that's a problem because father didn't rectify any of the problems that were obviously there. I mean, just going to the dental care, and I'm not saying it's a minimization, but the testimony of, well, that was mother's in charge of that. Well, father's also in charge of the child. He can't just put everything on mother. And you're trying to make the argument that we need to make a finding separate and apart, and I agree. Isn't that enough?
Well, I actually understand exactly what you're saying, Justice DeAngelo, but I think what I would step back, and the one thing I have to really firmly think is, I don't think father was responsible for the two older children.
I'm
Sure.
putting
No,
aside older children.
So take all that information out of the record and just look at what father, whether, as Justice Ditkoff says, put it on mother or not, what he might have. And perhaps, as he was working full time, he did put that on. But again, shouldn't the issue be reframed, and not once in the record? And this is the problem with this case is, in domestic violence, and I realize I'm out of time, but let me just say this one point.
You may conclude.
In domestic violence, right, we always say the victim in these types of cases, she's got to protect the children and she's got to get out of the household, right? We didn't quite have that in this case, and I say that sincerely. We had mother with, at best case, with a substance abuse, and it's not my issue, but the issue is relevant, is that the record doesn't show anything of how that would cause harm to child. It doesn't specifically. I mean, it's not like she left the kids in the mall. It's not like they were living in a car and mother was shooting up. That's not what we have here.
No, but she did have no teeth due to the sugar consumption. No. So there are some things here in the record.
No, my client has teeth. Fast forward, I'm not suggesting anybody should bypass dental or medical care, and let me be clear, but the child now, it's not like she's suffering. I'm not saying that excuses, but I am saying what is the atrocity, and I really say this sincerely, is this child, and I'm not going to go outside of the record, but focusing only on the record. But I would submit that if you went outside the record, it continues to get worse. But in 19 months, you took this away because they went from 2 different hotels. In DCF's custody, 4 moves. You took this away.
I'm going to stop you now, but I want to say that we appreciate your argument.
Thank you.
And we sincerely appreciate your sincerity and your passion. We appreciate both arguments. And we know these are very difficult cases. And we'll hear now from the lawyer for DCF, but that's not lost on us at all.
Thank you so much.
Thank you very
Your
much.
Good morning, Your Honors. William Cuttle for the Department of Children and Families. Your Honors, can you hear me okay?
We can, thank you.
Judge Vuono, can you let me know, I'm getting close to my time. I don't know if I'll need it all, but...
You have full 15 minutes, and you've just started. I'll let you know.
Thank you. I know you've read our brief, and I know you're very familiar with the findings. I just want to point out a couple of points that I think are worth reminding the court, and I'm happy to answer questions. First of all, this is not a TPR case. This is a care and protection case. The father and the child have every right, or could have had a right, to go back to the trial court for review and redetermination. The judge made this decision back on July 3rd, 2024. The court, in this case, if you look at all the findings in this case, there's 281 findings that the judge made. And it's hard not to come away, after you read all the findings, with the idea that the court took all these findings and the situation that this child was in very seriously. The court actually did not do what the department asked them to do, which was to terminate father's rights, mother's rights, because the court said in its summary of the findings and in many of the findings, which I'll get into in a minute, that the situation for this child was very difficult. I don't know the exact word. But quite simply, the court couldn't, based on all the evidence that she heard, testimony from mother and father and an expert and all the exhibits, could not send this child back to be with the parents in the home they were in, with the fact that there was no evidence that they had made any improvements. Father had made no improvements since the child was removed from his care. And
Counsel, I'm going to interrupt you.
Sure.
This is an unusual case, at least from what I've seen, where we have cases where things are bad, and I'm going to sort of summarize, paraphrase.
Yep.
Things are bad when with mother and father. When go to potential foster homes, things get better for the child. That's our usual case. Here, tell me why things are better when the child is in foster care than they were with mother and father. Because child's lawyer is kind of saying things are no better, and in some situations, well, things might be better in some aspects, but they're worse in others. So what do we do with that?
well, I think the court addressed that, and I'll answer the question in this way. The findings don't specifically say what troubles the child was having while in the different types of foster care that she was in. I went through the findings again in preparation for today, and the court found that the child was removed in November of 2024. As of April, 2022. As of April 2023, the child was doing well in the foster placement that she was in at first. She was with the middle brother. She started having difficulty in December of 2023 and had several months of not doing well and being moved and having behavioral issues. It's not clear what caused those behavioral issues. And to speculate, and I can't speculate as to that, and I'm asking this court not to do that either. There's no evidence to show what the reasons were. And clearly the child was not doing well in many respects during the middle period of her placements. By the end of trial, the court found that she was doing well, doing relatively well, I think the term was, and I'll rely on the findings as they are stated. She was doing relatively well in the star placement that she was in. She was doing very well in school, but she wanted to go home. And everyone knew she wanted to go home. And the court specifically knew that she wanted to go home. But to say that just because there were struggles that we don't know the exact reasons for, Your Honor, doesn't somehow justify sending the child home when the court had all this other evidence before her about unfortunately, the failures of the mother and the father to do anything to try to meet this child's needs and the other children's needs. That this whole argument that there was no evidence about father's unfitness is not based on the record. If you look at finding 31, finding 169, and specifically finding 281, the court clearly identifies father's own shortcomings. And to try to parse out between the mother and the father, they were a couple. They were a couple, and the panel has pointed out that father, his position was he works, mother takes care of the children.
If there's actually a question
Would you disagree that a more engaged father, that mother's shortcomings aren't so bad that an engaged father wouldn't be able to raise a child well, even in a household where the mother is?
Say that last part again.
What I'm asking you is would you agree that a more engaged father, a father who took responsibility
Yes.
for the child's care, would be able to successfully parent a child, even in a household with mother? Mother isn't leaving pills around for
As
child.
long as, I would agree with you in that, I think that's a possibility, without saying it's a certainty. I think the most important factor to keep in mind, though, is, and this is one of the factors the court was concerned about, and there were many factors, it wasn't just one, but one of the factors was father did not seem to have an understanding of the impact that mother's substance abuse problems were having on the family, on his child. He did not even consider that. He did not even consider, mother and father both thought, if the child just comes back home, everything's going to be better. There's no evidence to support that. But I do agree that if the father had been more active and took his child for the appointments and made sure the child went to school, and I'm assuming that if a father was doing that, the father would also be concerned about the impact that his partner's substance abuse was having on the family, he would also consider, then yes, it may be a different situation. Sadly, those aren't the facts here.
Hear you.
Are there any other questions?
I guess this is a hypothetical. Would this be a different situation if father agreed not to live with mother?
I don't know the answer to that, Your Honor, because, I mean, I know it's speculation, and I know you know that. I don't know, because there's no evidence in the record at all that father took any initiative to take care of his daughter. None. He didn't, he went to the, he didn't even, they had a private social worker. The department asked him to give us your parenting plan. They didn't do it. Father didn't do it. Father didn't give his budget. Father stopped going to therapy. The whole idea about whether he was dismissed or he stopped, it doesn't matter. He stopped going to therapy. He didn't think it was good for him. He didn't understand why he had to go. Unfortunately, he wasn't capable of taking care of this child at the time. Now the court in this case, and you don't see this as often as maybe we all should, but it struck me that the judge in this case said that it's her fervent hope that the parents make improvements for this child's sake. And that's what she did. But she couldn't turn a blind eye to the facts and the evidence before her about father's unfitness relative to this child. If there's no further questions, I'll rely on the department's brief.
If you wait just one moment, I'll check with the panel. I see no further questions. Thank you very much both for your argument as well. And I've already thanked all the parties for their argument today. We appreciate it. We're going to hear one more case before we take our morning break. And that's John Doe, number 524375, versus the Sex Offender Registry Board. This case is also impounded. It's case number 2025-0031. Don't worry about that. Thank you. As I say at home, it's just a little bit of water. All right. Good morning.
Good morning. Thank you. If it may it please the court, my name is Rebecca Rose, and I represent the appellant, Mr. Doe. Your Honors, before I start my argument, I would like to take just a moment on the record to acknowledge Attorney Shenai, who wrote the red brief in this case, and I did this from the podium last week, but I do want to express my condolences to his colleagues and also to his family. So I feel like we lost a very good
We appreciate that.
advocate.
And he was a terrific lawyer and husband and father, and we all feel the same way. So thank you for bringing that up.
Your Honor. Thank you. In this case, this is a difficult case. These are very difficult facts. But I submit that because these facts are so difficult, the need for a careful, considered analysis is really critical in a case that looks at first blush like really terrible facts. So an especially meaningful application of these validated risk factors is very important to make a future determination of future risk of sex offending. So as an example, just as an overview of the whole argument, as terrible as the offenses are, Mr. Doe did have one victim inside the house. And as difficult as the crime is, the empirical evidence says that incest-only offenders have a lower rate of recidivism.
Counsel, let's get right to that part of the issue that opposing counsel brings up, which is why aren't the scientific articles you say that the examiner either didn't consider or gave such diminished value to them was an abuse of discretion. Why aren't those issues waived because you did not bring them up to the Superior Court judge?
Well, Your Honor, I
At least
disagree.
some of the articles.
I disagree that they weren't brought up. He did argue that both the empirical studies showed a lower risk, and he also argued that it affected the finding on whether or not internet dissemination was important. He made that argument, and it was in his motion for judgment, and the decision was in the Superior Court.
As to all four, there are 4 articles that I think are mentioned in your brief, and again, it's difficult because some of the authors are the same, but, so and we'll go back and look at the supplemental appendix that counsel filed. You say that all 4 articles are referenced?
No, in fact, what I'm saying is the argument itself, that every bit of, Mr. Doe's counsel at the hearing introduced these articles, and he put it in his findings. He made the argument, but also the regulation itself and the articles that
Counsel,
underpin.
I think you're doing a good job, but may have presented them to the hearing examiner, but my focus now is what was presented to the judge. Was the judge in the memorandums basically saying the hearing examiner didn't consider 2 of these articles, therefore it should be remanded or whatever was asked for? Was that presented? And if not, why isn't it waived?
Perhaps as to 2 of those articles, not as to the factor itself, and certainly it was preserved as to the articles, the authorities that are listed in the factor. And he does argue about the Hansen case. The 1998 meta-analysis was a real kind of groundbreaking case, and there's not been anything since that 1998 article that has disputed the fact that there are categories of sex offenders, and incest-only offenders are at a much lower rate.
But doesn't the regulation take that into account by saying if it's not incest, then it's more likely recidivism? If it's a stranger, recidivism is higher. Isn't that just another way of saying, and if it's familial, it's lower? Well, it seems like logically the same statements.
Well, sure, but the hearing examiner didn't consider it at all. She didn't consider factor 7, and the argument below and our argument on appeal is that factor says it says that incest-only offenders may have a lower risk. It doesn't say it's a mitigating factor. But my argument to you and the argument below was that should be considered in the analysis, especially in a case like this that is incest
Isn't it
only.
considered in the analysis by not applying it as a risk elevating factor? Anyone who's not extra familial gets a risk elevating factor, and so by not giving that factor, you're reducing your recidivism likelihood.
Why is it in the regulation if it's not going to be considered? Why? I mean, and there is authority listed in that regulation that underpins what the regulation says, and the 1998 meta-analysis is one of those authorities, and that the SORB relies on. Dr. Hansen is a leader in the field of sex offender recidivism research. So my suggestion here is that really the hearing examiner just didn't make a meaningful and considered analysis. If she did, she would have talked about it. She would have talked about the fact that Mr. Doe was an incest-only offender, and that in fact was part of her consideration when she made the evaluation. That's the regulation. It's in there, and he argued below that the hearing examiner should consider that. That also relates then to the finding that internet dissemination was necessary, which is one of the elements that the hearing examiner has to find. And again, she didn't consider the fact that he didn't offend outside the house, and that he had only one victim. And in fact, this court you know, this court has said over and over again, and SORB has said over and over again, the past is prologue. So we look at what he's done in part to determine what he's going to do. And the hearing examiner, you know, suggested that, you know, friends of, you know, children of Doe's friends and acquaintances were going to be at risk, and that's why internet dissemination was important. And again, I argue that based on this record and these facts, and the fact that the hearing examiner should have grappled with the fact that he was an incest-only offender, and that's his only sex offense on his record. He has other offenses, but that's his only sex offense, and this is about predicting future sex offending behavior. And there's nothing that suggests that his victim pool is somehow bigger than intrafamilial. So again, and if in fact the hearing examiner was guided by the authority in its own regulation, I believe that there should have been a more considered analysis of his actual offenses and how they predict his future sex offending behavior. I would like to briefly talk about Factor 9 as well, and that was applied, and again, the factor itself talks about substance abuse. That it applies if there's a history of substance abuse, active substance abuse, or if substance abuse contributed to the sex offense itself. And again, I do think there's a distinction between use and abuse. He had an old marijuana possession on his record, and he had some Suboxone and a dirty urine when he was in prison, which there is a context for that. But again, she doesn't talk about abuse. She just says, oh, here's these charges, use, check, here's I'm applying the factor with some amount of weight. And again, I suggest that in a case like this, a more careful analysis is needed, especially on the Factor 9 as well. If there are no questions, you know, the Factor 12, Factor 10, Factor 11, again, if you look at the whole case, how many dismissed charges he has on his record, how old the charges were, how the threats sounded really serious, the threats to the family, but he was never even indicted on those threats. He was never even arraigned on those threats. I think it was a placeholder until they could charge him with the sex offenses. And you know, and even all of his tickets in prison, there was a really serious context for those about his own safety. They put him right into 10 block at Walpole, and, you know, right off the bat, he's in an unsafe place. And I think I'm not defending his behavior or the decisions he made to protect himself, but there is a context. And
Counsel, one thing that your friend says that I'd like to hear your reaction to is that whatever errors the examiner may have made, that considering the subject, the crime, and his sort of, you know, his just constant criminality, general criminality, not sexual offense criminality, that it just had to be a 3, no matter what. I'd like to hear your response to that,
well,
sort of the harmlessness error.
Well, and it's a serious crime. I'm not defending I'm defending his rights, not his behavior. And I believe that if you look at the empirical evidence, look at what the actual empirical studies say about recidivism, if you look at his actual sex offending record, it's a bad crime, but I don't think it predicts that he's going to be a serious, dangerous sex offender in the future. I think that this is about predicting behavior based on empirical evidence. And I believe that this case looks bad enough that it's very easy to check off the boxes without making that analysis. And even the crime itself is not the only reason. That's not the only reason you can, our case law says that. You can't just classify someone based on the crime. You have to employ these empirically validated risk factors. And my suggestion in this case is that the hearing examiner wasn't considered enough, didn't make the careful analysis that the Constitution requires, that his due process rights require. And I submit, if you look at the whole picture and add it all together, that it was inadequate to prove that he is a high-risk, highly dangerous sex offender by clear and convincing evidence.
All right, further questions? Thank you, Counselor. We see no further questions, and you can,
Thank you.
we appreciate your argument. Thank you very much.
Good morning, Your Honors. James Hands on behalf of the board. And before I start, I would like to thank my sister and the panel as well for their acknowledgments and comments on Attorney Shenai. So the evidence in this case shows that Doe, as an adult, repeatedly sexually assaulted his prepubescent, developmentally delayed sister over a period of at least 3 years. So the examiner, in classifying Doe as a high-risk Level 3 offender, relied upon substantial evidence concerning this abuse, as well as evidence concerning Doe's troubling history and circumstances, and her application of the regulatory factors, which postdated all of the research materials that Doe submitted, was neither arbitrary and capricious nor an abuse of discretion, and the Level 3 classification should be affirmed. I don't know if the panel has...
So usually, we see the examiner mention each of the studies and say, you know, that's already in the regs, or that's contrary to the regs, or I just don't, this is a cherry-picked study, like the Connecticut study seems to be. But there's some important studies here that just aren't mentioned by the examiner at all. Why isn't that a problem?
So I would actually suggest that the decision does address each of them. I think if you go back and check the entry for factor 37, she says, well, we have some of these that pertain to, for example, recidivism after release. We have, which she didn't apply because he was in custody at the time. She acknowledges that there were studies that addressed his sex offender treatment, which she didn't apply because he hadn't done sex offender treatment. I think she doesn't address some of the factor 7 materials because she didn't
reference factor 7 at all.
She
not
does-
in her decision at all.
Correct. And I think that that is perhaps an editorial mistake, but I don't suggest that it's an error within the context of the decision entirely. She acknowledged, I believe, in multiple places in the decision that this was an intrafamilial offense.
How can it be rational to discount a study on the grounds that he's in prison and these studies are about whether people recidivate outside of prison? I mean, isn't that what the examiner is supposed to do, figure out whether the offender will recidivate outside of prison?
Sure. I would suggest that, first of all, she may have given it less weight based on the fact that some of these studies were rather old and that they did predate the 2016 regs. They certainly predate, they're certainly old by the time this hearing occurred. Also, I would suggest, this doesn't, I don't believe she made this argument, but I do think that it is probably relevant here. It is that the question of recidivism upon release is something that is considered by the board's regs. It's considered under factor 29, which is the time in the community. That's a mitigating factor, and the board's research has shown that the mitigating weight really only begins to accrue after 5 years, so it's contradictory.
I mean, I can see lots of grounds for disregarding these studies, but the ground that she gives is, as offender remains incarcerated, I give no weight to these articles, and I don't know how we can accept that.
Well, I mean, he was incarcerated at the time. It wasn't entirely clear that he was going to be released. I think he was, I think, perhaps coming up on his rap date. I don't recall off the top of my head, but I think if you take a look at his overall incarceration history, it wouldn't have been unreasonable for the hearing examiner to consider the possibility that he might commit a new...
Well, let me ask you this. If the examiner doesn't think he's going to get released, why do we need internet dissemination if he's going to stay in prison? I'm not following that.
Again, I think, I don't want to argue both sides of this, but I think...
No, but I'm kind of trying to get you to argue one or the other.
Sure, okay, fine. I think the reason that she gave for not accepting those studies was because he was currently incarcerated and she didn't want to have to speculate on when and how he would be released. I think she did, on the other hand, say that he would eventually be released, and given the risk and the danger that he posed, that those justified internet publication. On that, I would suggest that you can look to 496501, which says that if a person is a sexually violent offender and they're found to be even a moderate risk and moderate degree of danger, then internet publication almost invariably serves a public safety risk. Here she was finding that he was a high risk and a high degree of danger. The other things, I know that my sister referred to this regarding the idea of his victim pool being small. So, is there a basis for, alerting the public where his victim pool might only be confined to the family? First of all, I think that relies on an assumption that once an incest offender, always an incest offender, which I don't think is the case. In fact, we have a separate factor, factor 21, that considers diversity of victims, and one of those would be, have you offended against both incest and outside the family? So we contemplate the possibility. The other thing...
Can I ask, going back to the article regarding incestuous relationships,
yes,
and factor 7.
Yeah.
How can we determine that the hearing examiner considered the relationship between the two when she doesn't reference factor 7 at all?
So again, I think she, in reading the decision, just the description of the offense and who the victim was, acknowledges flat out that that the victim here was the Mr. Doe's younger sister. There's no confusion.
Yes, it does that numerous times.
Sure.
I guess I mean, how do we make a decision that she considered the fact, as Judge Ditkoff said earlier, that because it was incestuous, there is less a risk of recidivism? How do we determine that she considered that?
So well, again, I think the better practice here editorially would have been to say, I note that factor 7 does not apply because this was an intrafamilial, and intrafamilial offenses are neither risk-raising or risk-mitigating. If she put that language in, I don't think we'd be having this discussion. Nevertheless, the fact that she didn't put it in doesn't change the fact that she acknowledged throughout the decision that this was intrafamilial, and she didn't treat it as risk-elevating. I think the idea that it should be risk-mitigating in some way is one that, first of all, runs contrary to the language of the factor itself. If she had put in factor 7, that language would have said this is not something that applies in a risk-mitigating factor or fashion. So, I think had it been included, it wouldn't have been applied in the way that Doe would like it to be applied. And that is something that this court has ruled upon in the past and affirmed denying applying it in a risk-mitigating fashion. It is, bear with me here, 524553. That's 98 Mass App Court 525. It's a 2020 case. A similar argument was made that it should apply as risk mitigating, and in analyzing it, they said, no, all that happens when it's intrafamilial is it sets the baseline, and then things go up from there, which I think is also an important distinction to maintain, is there's a difference between being of comparatively lower risk versus something which is actively risk lowering. And being an incest offender is of comparatively lower risk than a guy that, just attacks somebody that meets on the street, but incest offending is not something that is actually going to take risk off the top. I am going to do the graceful thing here and suggest...
I have another question, sorry.
Sure.
There's a comment in your brief, and I apologize, for some reason I didn't write the page down, but you seem to imply that a hearing officer should not consider any articles that predate the change in the regs of 2016. Do you have any case law or anything that supports that assertion?
I think the cases that support, I don't know if I would have phrased it quite that way, but
I read the cases that are in the brief, and I didn't see that.
I think the cases that are cited in the brief support the idea that the board has an obligation to consider research when it describes things that aren't presently contemplated by the board's factors. So, for example, you have 151564, which talked about age, which wasn't something that was that the factors contemplated, and not considering articles on it was found to be an abuse of discretion. You have 205-614, which was the case that contemplated difference in risk between female offenders and male offenders. And again, at the time that that was being offered, our regs didn't do that. Here, many of the things that were being offered are things that the regs actually already contemplate. Again, they do contemplate the idea of risk after release. It's just under factor 29. You know, and the Hansen and Bossier 1998 study that's mentioned, and that which the attorney who handled the classification below relied almost primarily upon in his MJOP. A lot of the other articles he just kind of left by the wayside, but those are cited by our factors. They're in our bibliography, so it's not as though the examiner was disregarding it. She was just applying the factors which derivatively contain the fruits of that research. I did want to touch on one thing, which is the waiver. Factor 7, I do think, was addressed below in the MJOP. I think if you look at Doe's MJOP from below, which I did submit last week, he does talk about factor 7 there. I think the factors that were entirely waived are factor 8 and factor 12. Those would be sort of violence during the commission of the offense, as well as factor 12, which is the, it's disciplinary in prison. That wasn't raised below, I think in part because it was very applicable on the facts. He had nearly 90. I know my sister alleged that, or raises the idea that like some of these may have been him refusing housing assignments. Even if you take those out, he's got things for assaulting COs, assaulting other inmates, attempting to smuggle Suboxone in, dirty urines, so on and so forth. Factor 9 was, I think, also raised below. It's raised on the grounds that marijuana was legal, and I would suggest that that's not actually really a good argument. The factor also considers alcohol. Alcohol's been legal with, you know, the brief exception of prohibition for 250 years in this country. You know, just the fact that it's legal doesn't mean that it can't be used or considered as having been abused. The fact that it was considered, I think, is based on the fact that, and the other thing that he argued in the MJOP is that substances were not used as part of the commission of the governing offense. He wasn't high, or he wasn't giving drugs to the victim, I think was the argument that was made. And that's not the only way that this factor can be applied. If you read the language, it's written disjunctively. It's whether or not he has a history, current indication of substance use issues, or if it was applied in the governing offense. And I would suggest 2 out of the 3 are satisfied here. He does have a history of substance use that goes back to, I believe, he may have gotten the DYS commitment on the basis of it. I'm not 100% on that, so don't take my word for it, but I know he definitely had something on his record from when he was young. And then when you get him into prison, he is continuing to again, have dirty urines, try to avoid or alter the outcome of urinalysis tests. And then there's also, I don't think it's something you got a D notice for. I think it's just in the DOC records, but they note that he has friction with other inmates because he's acquiring drug debts to them and not paying them off. So I think that there is ample support within the record for applying that. I am trying to think if there is anything else.
Well, I'll check with the panel in case there's anything else that they want to cover, and I see no further questions from the panel, so I think that you have covered everything.
Thank you very much.
Thank you both very much for your arguments in this case. We appreciate it. We're going to take our morning recess now. The court will be back in about 15 minutes. Thank you. All right, thank you for your patience. The next case we have after our break is K.D.F. versus D.M.F. 2025-0747, and the case is partially impounded, as I'm sure the parties know. All right.
Good afternoon, Your Honors. My name is Richard Novich, and with me today is my colleague Michael DiStefano, and together we represent the appellant, D.F. District Court's extension of the 209A order here should be vacated for at least two reasons. Our client was deprived of due process, and number two, the trial court judge appears to have based her decision to extend on improper legal considerations, and several of those. With respect to the due process piece, the record reflects several violations, I suggest. I'm going to start with the first one, which is improper notice. D.F.
Notice did come up in the middle of the hearing, right, as to what the...
Yes, it did.
Okay.
Yes, it did.
No continuance was asked for?
Nor do I think it would have been appropriate to ask for a continuance, Judge, under the circumstances of this case, and there are several reasons for that. I'm glad you asked. At the time, the plaintiff had sought the order. She's a Ivy League professor. From what I understand, that there are individuals who work at the courts called victim witness advocates who assist with these types of paperwork. At the time she filled out the application and the complaint in the first instance, she certainly should have known or must have known the basis for the relief. She checked.
So we don't know that because that wasn't discussed or any testimony about the hearing, right?
I do not know whether she had the assistance of an advocate. That's absolutely correct. But what I can say is the law in Massachusetts, as I know all of you are aware of, says that pro se litigants are entitled to no greater protections than those who are represented by counsel.
Right, but let's move forward. The fact of the matter is that we note that the coercive control was not checked off in the box.
Yep.
That's clear. Case goes forward on the theory of imminent fear of physical harm, right?
So it started off that way, but that's not how it finished, and
Exactly. It starts off that way.
And that's the issue.
There's a change midstream.
That's right.
And why is it you or the person who was representing your client at the time, well prepared, it appeared to me, couldn't pivot and continue on, which it seems to me happened here.
So the issue from my perspective, Your Honor, is I'm going to analogize it to the case where an individual is charged with one crime and then he's convicted of something entirely different. One of the cases that I cited and I provided to the court yesterday in the 16L letter is a panel decision.
That's very different. In a civil case, anything that isn't raised is waived. And when coercive control comes up, your partner there says, well, I'm happy to go through coercive control, which is very different than saying, that's a problem, you shouldn't consider coercive control. How do we get around that?
So from my perspective, Judge, in the if I'm going to pronounce the case correctly, excuse me, Commonwealth versus Awag-Barrow case, I don't believe it was appropriate to have my colleague or anyone else in that position to have to learn for the first time that there's a shift in the analysis. There's a shift in the theory.
So why doesn't he say, Your Honor, I'm not prepared for that. I didn't bother to read the restraining order that says coercive control, and so therefore you shouldn't consider that issue at all, instead of saying, well, I'm happy to go through it.
So at that point in time, I suggest that the trial court judge had very clearly made up her mind, and that's where she was going. Something had to be addressed with the court on that moment in time, and Your Honor's question of why wasn't a continuance asked for. At that point, D.F. Hadn't seen his children in several days at that point, and it would have been prejudicial to him to have to ask for another hearing. The second piece to that is, not only was the pro se litigant, she certainly should have known that this was a basis that she was seeking relief. She didn't check off that box. And from a fundamental fairness perspective, from a due process perspective fairness, the individuals who are preparing for those hearings, they shouldn't have to guess. You look at the affidavit and what...
You're correct. No one should have to guess. And, of course, notice is part and parcel and fundamentally a part of our law. So I think we can say, speaking for myself and the panel, that we can agree with you on that, right? But here, not only as Justice Ditkoff has pointed out, your colleague ably pivoted. He didn't, arguably, a great job. Went right through the factors, looked at each one, described how the evidence did not support it, and made the argument. So, I mean, no one should be penalized, I guess, for doing a good job. But tactically, can we not say that it behooved him and your client to go forward on that basis?
Debatable, I guess I could say, Your Honor. Let me move on to the next ground for due process violations,
All right.
as I see it. The second ground, as the cases from this court and the SJC over the last somewhat, more than roughly 100 years, reflect that our client was entitled to a fair opportunity to present his evidence before a jurist who had not yet made up her mind until the close of the evidence. What you've seen in the record, and I think it's crystal clear in the record, that the judge made up her mind within 42 minutes of calling the case. 42 minutes after hearing only from the plaintiff, not hearing from our...
A judge says, I'm extending the order based on 1 and 12 unless you have something to show me. And then your partner there says, I think in fairness, you should be given an opportunity before the court makes a determination. And the judge says, absolutely. So what, at that point, is the judge supposed to do?
So at that point in time, I think from a practical perspective, Judge, and that wasn't the only time she made that comment. She made a comment again, subsequent.
All right, but at that, let's take that moment in time. What's the judge supposed to do? She said, absolutely, client will testify before I make a determination. What else is she supposed to do at that point?
At that point in time, she should have arguably confessed and said, maybe we ought to move this over to a different judge at that point in time.
All right, now, you know what I'm going to ask next.
Sure.
When did your partner ask for that?
He didn't, Your Honor. He didn't, and I'm not sure that that justifies any waiver here. The judge, again, a few pages later, made the exact same comment. A third time, she said, I find the plaintiff credible. Again, Your Honors, this is before she ever heard a word out of our client's mouth, ever heard or looked at...
Then he did testify at length.
He did.
And in detail.
He did, and at that point in time, under the Preston versus Peck case, I would say that was largely a moot point. The judge had already tipped her hand. She had already indicated that she had made up her mind, and this is what she was going to do. The fact that my colleague had to remind her, most respectfully to her, that our client hadn't even testified, I suggest and submit that that was likely an epiphany, and oops, I probably shouldn't have said that. But when you read over the Preston versus Peck case from 1930, I believe that it's abundantly clear when the trial court judge makes comments like that in the middle of a trial, that the defendant is deprived of due process and the case shouldn't proceed.
If we were to agree with you that the order should not have been issued based on insufficient evidence, do you still want us to address the due process claim?
If you decide that there was insufficient evidence, do you need to get to the due process claim? Is that the question? The answer is no. I don't believe you need to get to the due process claim, and I think a similar issue was raised in Your Honor's case of, I believe it was HM versus... Excuse me.
The unpublished decision in your addendum?
HM versus MS. I believe the issue was raised in Your Honor's case in 2025, where I believe this court, a panel that you were on, Your Honor, Justice Ditkoff, determined that there was insufficient evidence to justify the extension of the restraining order, so you decided not to get to the merits of the due process argument. I think that was in one of the footnotes.
And that was not under, the statute had not yet been amended at that point.
That's correct, Your Honor, but in another footnote, the panel referenced that had that case been decided under the coercive control,
the outcome would have been the same.
the decision still would have been the same.
I read it.
The facts of this case are, no case is identical, to be sure, but the facts of that case were certainly markedly similar to those here. So to the extent that the court gets to the merits of that, as I've set forth in the brief, and I wasn't going to regurgitate what I've said in the brief, but if we get to the merits, I'd rely upon what we've said in the brief.
Let me ask you this. What do we do if we think there isn't enough evidence for coercive control, but there would have been enough evidence for imminent threat, where the judge said she's finding it under coercive control? If that's what we find, what do we do next?
It's a great question. I hadn't thought of that. Based upon the record that we have, and based upon my current recollection of the cases that we cited in the brief, with all respect to Your Honor, and obviously I respect you quite a bit, I don't know how you could draw a conclusion that there was evidence of that in the record.
Well,
But that's not the question.
No, I understand.
If we decide that that's the case, sorry to interrupt you, Justice D'Angelo.
I think he's playing for time.
No.
What about
Happy to stay as long as you let me.
incident getting within inches of her face and saying, quote, "You're going to get what you deserve. I'm going to come for you." Isn't that enough on the single act intended to threaten, intimidate, harass, etc., coerce or compel compliance of a family or household member?
I don't, Your Honor, and there's a case that I've cited in the brief, and I've tried to write down the exact quote for you. But I don't believe from an objective standpoint that what was said would satisfy the statute.
Well,
subjectively, maybe. It may give her apprehension subjectively, but from an objective standpoint, under the case law, I don't believe that that would rise to the sufficient level to demonstrate an imminent fear of serious bodily harm. Based upon that solitary comment, especially given the uncontested record that reflects that there was no history of violence. She acknowledged there was never any physical, physical assaults. There was never any threats.
Well, doesn't that...
Isn't that why the statute was amended?
Yeah.
Isn't that precisely the reason why the statute was amended, to include coercive control for that very reason?
It may perhaps in part, Your Honor, yes.
I mean, that's because you're taking, and I respect the way you're taking it, the quote, "I'm going to come for you." You're saying that is more like legal proceedings as opposed to, "I'm going to come and kill you." Because it could be interpreted either way.
So that's how I looked at it, and I appreciate very much trial court judges can draw their conclusions and their credibility assessments. But I'm looking at it from an objective standpoint, given all of the attendant circumstances. The parties are still living together. They're trying to craft a parenting plan. They're in the midst of a divorce. They're having a dispute about the divorce. She's unilaterally taking away certain rights and privileges and time that he has with the children, and he reaches out to her by way of email.
I'd suggest you actually use, I know you don't want to credit the judge on this because you're kind of saying, I would suggest you take her, what she says. Number one, no abuse by harm, threatening, or attempting to harm the plaintiff physically. So she found, I think, that statement, "I'm going to come for you," was not a threatening statement in the sense of physically. She's getting to, that's coercive control. And I know you're arguing it's not, but I'm not sure why. I mean, the judge made that finding, and I don't know if that's an abuse of discretion, if that's how she's making that finding based on that statement.
So I'm not challenging that finding, nor could I challenge that finding. What I'm saying is that based upon that one solitary statement, that it wouldn't rise to the level to get to the issuance and the justification for the extension of a restraining order under all of the attendant circumstances here, that I don't believe should be ignored, regardless of whether the statute was changed in 2024.
Can I ask you about your notice argument? Because it goes to I can't remember, I think one of my colleagues asked this. If she had checked off both boxes, which the plaintiff could have, threatening and coercive control.
Would not have been an argument that I'd be making.
What would have been different? I guess it's almost like a harmless error. I mean, all the facts were presented by the plaintiff, and I know you're saying the judge made the determination. Let's put that aside for a second. Then the defendant was able to testify about all the stuff. How would notice have changed this at all?
So here's how I would answer that most respectfully. The case that I cited in the 16L letter. Again, I'm going to destroy the name of it, but the Awag Borough case. It's akin, as I see it, it's akin to someone being charged with one crime and then being convicted of something else. And in that case, the gentleman was charged with, I forget the statute, Chapter 276, Section 5. The judge then gave the jury instruction under Chapter 276, Section 28.
But why isn't it more like amending the pleadings to conform with the evidence at trial, which you can totally do in a civil case?
In a civil case, no doubt about it, Judge, but given the jeopardy that our client arguably would have been in, given the nature of the complaint, right? If a complaint issues under Chapter 209A, he has wide sweeping potential criminal consequences that do not flow in civil cases whatsoever. And I think a heightened consideration needs to be given for that reason alone. If she had just simply checked off that box, we wouldn't be having this argument likely today. But she didn't. As a pro se litigant, she was entitled not to do that. For whatever reason, that's what she elected to do. When the case started, she acknowledged that that was the only basis that she was seeking relief. She was cross-examined on it. She acknowledged that was the only basis. And in fact, if you read the record, right up until the time that the trial court judge, midway through cross-examination, but during her own examination of the witness, it appears that the trial court judge interpreted what she was looking for was under Section 1B, not 1D.
There was a pivot in the middle of the hearing. I think we can all acknowledge that. But time is almost up, and I want to go back to the question that Justice Ditkoff asked, which is also on my mind, which you did not exactly answer, which is, if we were to determine that there was sufficient evidence to issue a 209A order based on imminent fear of physical harm, what do we do?
But not on coercive control.
Exactly.
So if the court concludes that there was sufficient evidence, what do? You, as much as it pains me to say it, you affirm.
We affirm we don't have to remand?
You affirm, I suppose that...
Because the judge determined this case only on Section 1, right? Only on coercive control.
If the judge if the judge did, which she did not, if you conclude otherwise, which I don't suggest that there is evidence in the record to do that.
We're not trying to we understand your position, but you're also a seasoned attorney. We want to know what you think about what we should do. Should we decide this, which I'm not saying we have. Actually, we haven't.
But I also have to say that I still, regardless of that, there are, as I see it, there are serious due process issues in this case.
Would you say then we can affirm, because we can affirm on any other theory in the case, or do we have to remand?
So in the case of, adoption...
That's a yes or no. That's a one or the other.
So no. Adoption of TIA, there was overwhelming evidence to justify what the trial court judge there, despite the comments that she made from the bench, which this court found to be quite troubling. This case does, I would suggest, this case doesn't have those expansive justification to do what I think what Your Honor is suggesting, that if you find those facts to justify the issuance of the order. Again, we still have the due process issues
I got
that have been
so
cited.
I'm not going. You don't need to conclude again, because you've done a nice job doing that already. So I'm gonna stop you there. But I will always check to see if the panel has any additional way. Thank you very much.
Thank you all.
Appreciate it.
Justices, Sandy Derlin on behalf of the wife in this matter, the appellee, good afternoon. If I may address the issues you were just raising with counsel, I think that if Your Honors find that there's sufficient evidence vis-a-vis an imminent threat, I think you certainly, can affirm, and I think you can remand for an entry of an order which adopts that relief, the imminent threat, as opposed to
I think I said imminent fear before. I apologize. Yeah.
Sorry.
Right.
But on the issues that counsel has raised, in the order that he's argued, the due process and bias and so forth, first of all, the notice issue, the due process issue, is somewhat perplexing to me, because it's clear, and I think Justice Ditkoff raised this perhaps, I apologize if that's not correct, but the judge who heard the ex parte hearing, Judge Kennedy, I believe it was, she is the one who added that relief. It was not in the complaint. We all can agree. We can read the document.
I would say I alluded to that.
Yeah, but the reality is that
What do you
the
mean
father
by
in this matter.
What do you mean by added the relief?
Well, it wasn't sought by the mother in her complaint. The judge drew that conclusion during and after the conclusion of the ex parte hearing. Okay. She's the one who hand wrote the coercive control component in her order. That's a handwritten and
On the ex parte order.
Wait, can you?
In the ex parte order.
Point out where?
Well, I can direct you to my brief, which is on page 45.
It's on 13 on the very bottom.
It's 14 on the very bottom, I believe. refrain from engaging
stick
in
with 13.
coercive controlling behavior
So
as
that
defined.
puts him on notice.
Oh, box 14, I was being page 13 of the
Oh, sorry,
appendix.
it's
Yes,
box 14.
Box
So you
14.
think that puts him on notice that they're going forward on coercive control?
I do, because he was notified the day of, he was served. He was served on the day this order issued. That was the 9th. The hearing was on the 22nd, which is 13 days later, plus or minus. So he certainly had some notice prior to the commencement of the two-party hearing. And again, the issue of waiver does come in with respect to the two-party hearing and it not coming up. The notion that somehow it was important not to continue the hearing because of custody hadn't been determined. It wasn't determined in the 209A order, and there was pending proceedings in the probate court, which he could have availed himself of on that point. So I think the issue of notice is a bit of a red herring, because I think it was either waived and or he was given sufficient advance notice. With respect to...
So I just moving back to, the judge finds there is coercive control. I'm extending the order based on that. So if we find that it's only supportable on imminent threat, how can we affirm? Don't we have to send it back for the judge to decide whether there was an imminent threat?
I think Your Honor is like the trial judge, can conform the relief to the findings that
The relief, sure, but how do we know she found all the facts that would support the imminent physical threat? We know she thinks she found facts that support a coercive control, but maybe she didn't take the "I'm going to get you" comment to mean "I'm going to physically get you," but to mean "I'm going to go after you legally." Like, how would we know on this record that she made enough factual findings, even though the record would support that, to actually issue the order that way?
Well, I think the amendment adding coercive control to the abuse definition expanded the relief that the court can issue. And I think within that definition of coercive control, there is this notion of coercion and threat and so forth, which I think speaks to the fear, and the fear can include reactions, from the perpetrator. And I think that's exactly what the wife testified to in this case, about her concerns over that behavior, that menacing behavior, the isolating behavior, the impingement on personal autonomy and whatnot. And she testified to how that might further manifest itself as the case went on. And when you looked at when the trial judge looked at the totality of the circumstances, I think she could draw the conclusion that both, imminent harm could flow from the coercive behavior, the way the credible testimony that the wife gave about, how he might react because of what was going on in the divorce case. The incident which the husband denied regarding the child, all of which I think can lead to the conclusion that she was reasonably fearful.
Right, but can lead, is that enough? Or how do we know the judge found it did lead?
Well, she didn't. She didn't make that finding, and she didn't have to, in my opinion, I guess is what the point I'm making.
Why? Just because she said that the plaintiff, that the wife here, was credible? Because is that enough for us to following just to cause questions?
Credibility obviously is a linchpin, but ultimately.
It's just because you find somebody credible, don't you still need to make some findings?
Yeah, I was segueing to that. The reality is what you have here is testimony, not conclusory testimony, specific details about behavior, which I think fits the definition of coercive control in this case, which also speaks to the fear that the mother had about what might come next. And I think that's how I look at this situation.
What do you mean, what might come next?
The fear of how the husband might further react as the case.
But she makes a finding that the conduct was not threatening.
Was not, excuse me, Your Honor?
She makes that finding on page 93. So number one, no abuse by harm, threatening, or attempting to harm the plaintiff physically.
Well,
so she's saying, I don't find there's enough that there was a threatened of her physical safety. So what is the threat of that you're saying is clear?
I think the definition of coercive control includes the fear of the, to use it, I mean, perpetrator, whatever, the defendant, however you want to characterize it. I think it allows for protections over a fear of what might occur in the absence of the order, given the behavior that the judge credited, I guess is the best way I can put it. So in my view, the due process and notice requirements I think they missed the mark. And as I said, I believe her testimony, the credited testimony, satisfied the very broad definition of coercive control that was added. And that, from my perspective, is perhaps the crux of this case in terms of whether or not Your Honors conclude that that evidence that was credited is sufficient to satisfy the definition in the statute. I dare say it is.
Let's talk about the credibility, which is, it seems as if the judge found your client credible before hearing all the facts of the case.
Well, she said that.
Yeah.
I mean,
so what do we do with that? Isn't a judge supposed to hear all the facts before making a credibility determination?
well, I think it may not have been the most elegant way to express herself, but the reality is, and as I think perhaps all three of you have alluded to, she did invite testimony. She did give the husband his opportunity to tell his side of the story. Another way I think you can look at it is in the context of when these comments were made, in some respects, the judge was effectively saying, listen, she's met her burden on this issue, but I'm still going to hear from the husband, and that's exactly what happened. So I don't know if that comment in and of itself foreclosed.
Even there, is it appropriate to determine?
I'm sorry?
Even there, is it appropriate to determine that a burden has been met before hearing from the other side?
Well, I think
we can agree now.
Well, I think if for example, the mother had simply testified in very general terms, the general apprehension and that sort of thing, I think a judge could say, you haven't met your burden. I don't need to hear from the other side. You know, I think that, and in this case, I think what she was...
I think I'm just going to add, although, of course, we're not there, we're not fact finders, we don't see demeanor, but the husband provided compelling testimony.
But it's within her purview to credit or not credit. And in this case, I mean, I think when you look, and I know you have, when you look at the transcript in the context in which this all occurred, I think the judge was effectively managing the trial, essentially saying, I've heard enough from mom, let's move on, I invite testimony from the father. And while the words were, I find it was credible, I mean, it was credible in the sense that, you know, she met her burden. It may not have been the best way to express it, but the reality is, father got his proverbial day. He was given the opportunity. His counsel was very rigorous in challenging the judge and on a number of different occasions. And in the end, the judge effectively did not continue the order until she heard from both sides.
I may agree with you that if the judge had just said, I'm finding her credible, stop, and then still heard from the other side. She didn't say that. She didn't just say she's met her burden.
She said 1 in 12.
I'm extending the order for 1 year. She made a decision.
Well, but, you know, it's within, I mean, not to be flippant, you know, the old expression, it's a woman's prerogative to change her mind. I'm not being
Oh, yeah,
flippant.
you don't want to say that.
But, I mean, the reality is, she did say what she said, the record reflects what it reflects, but she then allowed the husband to hear the husband, and she then
So if
credited
she
it.
had said, I've already made up my mind, I'm going to extend it for 1 year, but yeah, sure, put your client on. It's not going to mean anything. Go ahead.
Well,
Because that's one way to read that, isn't it? Yeah, go
Well,
ahead. I've already made up my
I
mind,
think-
I'm extending the order. Go ahead, put your client on.
I think that,
Or as your brother said, it was an oops moment. I better hear from the other side.
well, I mean, I don't know how you can draw that conclusion on this record.
I'm just
but
pointing out that that's.
I understand, I
How about
realize
be-
that.
How about because not only she's getting a date from the clerk to write down on the restraining order of what the 1 year date is. Almost like she already wrote it, and then ready to hand it to the clerk. My client has to testify. Oops.
Well, but even then, she still allowed the husband to have his opportunity. And,
that's
you
true.
know, she didn't put pen to paper.
Certainly wasn't the best way to conduct an evidentiary hearing, is it?
I mean, I will leave that to your conclusion, Your Honor. And in this situation, you know, you've got these 209A hearings, which tend to be somewhat, they can be free-for-alls. And in this case, the judge was managing this process, was trying to move it along. I think that was in part her.
There can be free-for-all, especially if there's two pro se individuals, and these are, of course, always emotionally charged, but in this case, there was able counsel on both sides.
Right, but I think in this situation, the judge was effectively, you know, I know what she said, the record says what she said, but she was effectively saying, I've heard enough on this issue from Mom. Let's move forward.
Well, you made a good point earlier. We'll decide. We'll decide that.
So, unless you have any other
I
questions.
don't think so.
I
Let me
won't
check on the
belabor the
panel
point.
here and here. No.
right,
Thank you very much. Thank you all very much for the argument. Sometimes even cases that appear simple in the beginning are quite complicated and tricky as we go along. So thank you for answering all of our questions. We appreciate it.
Thank you so much.
All right, we have one case left today. It's Sheldon Manuel, now Sheldon Landon versus Burke, Timothy et al., 2024-1413. Thank you for your patience waiting for the case to be called. We appreciate it. Just a moment. Okay, you ready to go forward? Okay. Counselor.
Thank you, Your Honors. Good afternoon. My name is William Pudlow. I represent the appellant, representative of the estate of Sheldon Landon. I think our brief is brief because it deals with two civil issues. Did the judge err in failing to apply the extended statute of limitations under the Bankruptcy Act? And two, did she make findings of fact in error regarding when the statute of limitations ran and when it applied? Contrary to law regarding summary judgment, and so we believe that nowhere does she address in her order the application of 11 U.S. Code 108A. It was raised. My brother would argue in his brief that we waived that argument, but no, there's sufficient.
So let me ask you this, jump
Yes.
right to it. Where in the summary judgment record is the bankruptcy filing?
Is the bankruptcy filing?
Yeah.
It wasn't part because she was still in bankruptcy at the time.
Well, where's the filing for bankruptcy or the docket from the bankruptcy court or anything that would show that she had filed for bankruptcy?
Oh, it's in the appendix.
In the summary judgment record? It was in the summary judgment record?
It's in the appendix, and it is,
Not the appendix filed here. I believe the question is directed
Well,
to...
but yeah, I mean, where's in the appendix actually would be helpful as well.
Yeah, okay.
I'm sorry, I didn't,
I interrupted. Excuse
No,
me.
it's, go ahead. Where would I find in the summary judgment record the bankruptcy filing?
simply the argument in opposition to the summary judgment.
But doesn't a summary judgment decision have to be based on evidence in the summary judgment record?
It's not an evidentiary hearing. It's a determination that there are no material facts in dispute. And certainly, the statute of limitations is an article in dispute. In fact, my brother raised it.
Right, but how can the judge consider whether a bankruptcy filing stays the statute of limitations when the bankruptcy filing isn't in the summary judgment
In
record?
the transcript of the hearing, it's brought up before the judge.
I know you mentioned the hearing, but if it's not in the summary judgment record, how can it be a basis for a summary judgment decision?
Because I guess the summary judgment record is our opposition, which includes that. There's no affidavit or no copy of the docket per se, but the court was made aware of the application of that statute at the hearing. And it was mentioned in the opposition to the plaintiff's motion for summary judgment. So our position is, in fact, in my view, and on the research I did at the time of writing of the brief, there's no Massachusetts law on this issue. It's kind of a first impression case. Does the statute, federal statute, impact the statute of limitations in Massachusetts? We say it does. And we say that her filing didn't toll the statute, it just gave the trustee who had her estate at the time of the filing the right to extend for 2 years after the filing when he had to meet a statute of limitations.
Right, so how does the complaint get filed in Landon's name before the trustee abandons that asset?
Because the trustee approved by an order to appoint myself and Mr. McHugh from New York as counsel to file this complaint. We had authority under the bankruptcy judge.
I looked in the bankruptcy case. I might have missed it. Where am I going to find that order before the filing of the complaint?
Boy, where is that?
I didn't look at everything because it's Pacer, so I'd have to pay 10 cents a page, but...
Just give me a moment, Your Honor.
But if you give me a document number, I can pull it.
Of the bankruptcy?
Yeah, if you give me a, or I mean, if it's in the record, I didn't see it, but if you can even tell me what entry or even when it happened in the bankruptcy case, I can go into Pacer and
Trying to
pull it up.
locate it quickly here, Your Honor.
But I certainly don't want to download everything in the bankruptcy case.
Oh, that's fine. I'm sorry, Your Honor, the bankruptcy, the case, it's case number 19-11005-M as in Michael.
Yeah, I apologize, but you're telling me I'm going to find a filing in there appointing you to file this lawsuit?
Yes. I couldn't do anything without that authority because the trustee had full authority at that point over her estate.
So why doesn't the
claim was listed in the estate?
Why doesn't the case say estate of Landon versus Burke? Why does it say Landon versus Burke?
Well,
like why isn't the bankruptcy estate the party in the complaint?
Mrs. Landon was alive at that time.
Right, but the asset, the claim was owned by the bankruptcy estate.
Correct.
So why isn't the lawsuit bankruptcy estate of Landon versus Burke?
Because the trustee appointed us, myself and Attorney McHugh, to proceed with filing the case in Massachusetts.
But shouldn't you have been filing on behalf of the bankruptcy estate instead of Landon?
I think our pleadings do indicate.
You call her the bankrupt, but I mean, it's very different if the bankruptcy estate is suing than if she's suing as a debtor not in possession.
I'm sorry, Judge?
I said it's very different if the bankruptcy estate is suing versus Landon as a non-debtor in possession suing. A debtor not in possession.
It is the bankruptcy estate. Until such time as the court abandons, or the trustee abandons the claim, it is the property of the bankruptcy trustee, and we were proceeding upon his authority and the agreement we made with the trustee to file the suit and prosecute it in Massachusetts. And so our case went forward, and then the trustee decided he didn't want to wait around until that was done and abandon the claim. So she had the right to proceed then on her own with that claim, and that's what she did.
Keep going.
Did I respond sufficiently, Your Honor?
Keep going, yeah.
Okay. And so I guess our position is, had the judge who had awareness of the fact that we were raising that at the summary judgment hearing, if not in our opposition, to examine that statute and see the applicability to this particular case. Our other claim was that it was error for her to make a finding of fact as to when the statute of limitations ran. That was a matter for a trier of fact. In fact, my brother raised the statute of limitations as an affirmative defense in his answer to the complaint and never once raised the issue of the bankruptcy court. But basically, that matter should have been subject to a trial by the trier of fact. It's a defense. It's not an absolute right to say, oh, the bankruptcy didn't affect it. Oh, folks, we don't have to worry about that. The statute of limitations ran. The judge doesn't have the prerogative to make that decision as to when the statute would run. That would be for the trier of fact. And we believe that it wasn't afforded Ms. Landon at that time, before she passed away, to do that.
Well, how could a trier of fact find that the Norfolk case claim was still alive when the bankruptcy filing happened? That 3 years hadn't run from the accrual of the I'm not talking about the Barnstable case yet, but the Norfolk case.
The Norfolk case, well, that case was on appeal, so...
No, I mean the claim about the malpractice in the Norfolk case. So the judge finds that that no reasonable juror could find that accrued any later than March 20th, 2016.
But again, she's making a finding of fact. She's making a determination.
Well, there's no dispute.
How could a jury find differently on the summary judgment record?
Based on the testimony of all the parties involved and based on all the evidence that comes in at the time of trial. You have to weigh it all, and if the plaintiff fails by a preponderance of the evidence to prove their case, it's over. If the preponderance weighs in favor of the plaintiff, statute of limitations issue is moot.
Well, that's how it works in terms of going to trial. But in this case, where's the dispute of material fact with respect when
statute of limitations ran? That's the dispute. We're saying no, it didn't run until the additional 2-year period that was granted under the bankruptcy law, and therefore we filed well within the applicable statute of limitations.
How is that a question of fact as opposed to a question of law? How is a jury going to determine when a statute of limitations runs or not?
Based on evidence, they'll have to
But
assess.
But the evidence is supposed to be in the summary judgment record both ways.
I
That's how
don't
judges determine.
necessarily concur with that view. My position is that's a fact issue. You cannot, on summary judgment, make a determination of a material fact, and that when the statute of limitations ran is a material fact. It's not just simply a fact. It's essential to the rise and fall of the case.
Isn't the question of law, though, whether the bankruptcy transaction, in essence, tolls or extends the statute of limitations? That's a question of law, right?
Yes, but the factual issue that underpins that and gives you the ability to make that analysis is a fact issue.
Which is the date that the bankruptcy is filed?
No, it's the date on which the statute of limitations began to run. If it began to run...
Which under the law would be notice of malpractice, right?
Correct.
All right. So by analogy, for example, I break my leg today. I go to the hospital today. There's medical malpractice on setting my leg today. I wait 8 years. But when does the statute of limitations run? Well, when it started, when the event happened, there's no material dispute of fact with respect to that. Today is the day that I went to the hospital and had this issue, right? So I think what you're saying is that no matter what, on summary judgment, when I file a complaint 8 years from now, that could not be dismissed on summary judgment because it's a question of fact.
Material fact.
But there's no dispute that the event happened on today.
But that's different than this particular case, Your Honor. I think in this particular case, you've got a woman who is trying to work with her lawyer. Quite frankly, her lawyer doesn't appreciate her or like her. And consequently, she's near hysterical when, for example, in this case, he serves her interrogatories and requests for documents. She provides all the information. He never files any responses.
All right, so just to be clear, then, what your position would be is that it's not clear when, and I'm sorry, the client that's unfortunately now deceased, determined that she had a malpractice claim.
Correct. And
that although she may have even said, hypothetically, you are fired because you're not, because of how you are proceeding, not enough. That's still a question of fact.
Well, in this particular case, Your Honor, he moved to withdraw long before, and he wasn't allowed to withdraw for nearly a year plus.
I just want to make sure I understood exactly what your position was on that.
It's a material fact that has to be determined even in summary judgment, because summary judgment is strictly the law. And if she didn't apply the bankruptcy law, she couldn't do it. And we're saying that that combination of issues requires this case to be remanded and returned for a trial.
Okay. Any further questions?
Any other questions?
No further questions. Thank you very much.
Thank you, Your Honors.
Good afternoon, may it please the court. I'm Chris Storm for the appellee, Attorney Tim Burke. Respectfully, I do believe that the bankruptcy tolling argument has been waived. It was not an argument that was made in the summary judgment brief of Ms. Manuel Landon at oral argument.
Not sure I'm getting that. In that opposition, it says, the bankruptcy filing further told the statute of limitations regarding any and all claims which the petitioner's estate held as part of her estate. Why isn't that raising it?
Well, without reference to the statutory title, Your Honor. I would submit that a general reference to a concept of tolling associated with bankruptcy doesn't ring the bell. But even if it were raised, and even if it's not waived, it doesn't apply in this case. And the reason it doesn't apply in the case, as I think you appreciate through your questions to my brother, Your Honor, is that it applies to trustees and debtors in possession. It does not apply to Ms. Manuel Landon. Now, my brother has taken the position that he was operating as a designated agent of the trustee. I would submit that the record, both on the summary judgment level and in the appendix here, doesn't establish that. I am confused as to the comment that the claim was listed in the bankruptcy. I don't see it listed, and I address this issue in the factual background portion of my memorandum. Just to direct you to the page, it's page 18 of my appellate brief. So I do have some significant questions as to.
And it's in the abandonment, right?
And it's abandoned. It's abandoned.
In the notice of abandonment, it's in there, right?
Yes, it is. It is in the record in the notice of abandonment. And I think the key thing that really puts a pin on the issue is that a claim once abandoned, when the statute of limitations has expired, the debtor no longer has the protection of that tolling. It is a protection that is personal to the trustee or debtor in possession. And I would direct.
Well, I mean, I don't know that there's facts to support this, but if the trustee filed the lawsuit and then decided to turn over that asset to the debtor, wouldn't you think the debtor would get the benefit of the statute of limitations, assuming the trustee had filed it?
That would, as a non-bankruptcy expert, that would seem logical to me. Consulting with a bankruptcy attorney in the course of this appeal, I was surprised to find out that's not the case. And I would direct you, Your Honor, to In re Marshall, 307 Bankruptcy 517.
Wait, a little slower.
Yes. In re Marshall, 307 BR 517, 2003. In particular, I think pages 520 through 521 address this issue. The benefit, I'll just read from it briefly. The benefit of the extension granted by Section 108 is for the benefit of the estate and is effectively personal to the trustee. Continuing on, if the original statute of limitations has not expired when the extension expires, the debtor may pursue it himself. If it expired during the pendency of the bankruptcy case, the debtor may not pursue the cause of action. A little further on, the extension does not extend the statute of limitations. It merely grants the trustee and only the trustee an extension of time. So I do think in a situation...
Right, but if the trustee's already taken advantage of that by filing a suit, why would it suddenly become untimely when the trustee decides, and doesn't have to give it to the debtor, could give it to one of the creditors?
Yeah, because my understanding is that once it's abandoned and it's no longer part of the bankruptcy estate under this case law, the debtor is out of luck. I agree. It seems like an unusual principle of law, Your Honor, but I believe that to be the law.
No reason it would happen, but the person you consulted with, did they tell you whether when a trustee files a lawsuit, whether they do bankruptcy estate of so-and-so versus whoever, or if they just write the name of the debtor?
I think Your Honor is correct. I think, and I've always seen it where the bankruptcy trustee is indicated in the caption and brings the lawsuit on behalf of the estate.
So you would agree at the time of the summary judgment, it was not a fact in dispute that bankruptcy had been filed, correct?
I agree. I think that's,
Even though there was no document attached, that was clear, both parties agreed to that, and the judge could have accepted that as true.
Yeah, I think it could be taken judicially noticed.
I don't know that that's a concession, by the way, but thank you for making it clear for us.
You're welcome. I can further speak to the statute of limitations if the panel has questions about the accrual date or the continuing representation doctrine, which I argue in my briefs does not apply here because the continuing representation doctrine is inapplicable where the malpractice plaintiff has actual knowledge of alleged harm, and I would submit that the record in this case is replete with ongoing and really quite direct allegations or statements by Ms. Manuel to her attorneys that she's been harmed, that he doesn't like his conduct. I don't think I need to get into the details, but I'm happy to.
Do you know who provided the medical records to the Barnstable judge from the April 27th 2017. And the reason I ask is because Burke gets replaced, and I can't tell whether it was McHugh or Burke who provided the medical records.
I believe, Your Honor, the initial order that the judge entered, and I think I only included the amended order of dismissal in the appendix, but the initial order of dismissal on the day of trial ordered Burke to go to the hospital and get the records and bring them to court so the judge could make a determination about the appropriateness of the excuse not to be in trial. So I believe that Attorney Burke did it under the direct order of the judge, and I believe you would find that in the initial order of dismissal that the judge entered on the day of trial.
And I'm not wrong that those medical records themselves are not in our summary judgment record?
I believe you're correct. I don't think they are. With regard to the Barnstable case, I believe it's time barred by the statute of limitations. I believe the way that the court looked at statutes of limitations and how they accrue when there's an ongoing representation, this case is similar to, I believe, Justice D'Angelo's case of Alves versus Cohen. In that case, the panel found that an accrual date was earlier on in a representation when a demand for additional payment was made, notwithstanding the fact that there was also a specific allegation of malpractice with regard to some post-trial motions. So I would submit that the whole ball of wax accrued in March of 2016 because the allegations were all cut from the same cloth. But even if you didn't apply the statute of limitations to the Barnstable case, I would also submit that there's a complete failure of causation here where the dismissal of that case went up on appeal before this court and the dismissal was affirmed based on the plaintiffs committing a fraud on the court. And so there cannot be legal malpractice against Attorney Burke for anything related to the Barnstable case where she had a trial or a trial date. She did not make it into the courtroom. The events described in the brief followed, and there was an order dismissing it based on her own conduct. So
that's why I asked about the records, because if he mishandled explaining to the judge why she didn't show up, it could be on him. But it seems like he's out of the case before any motions are filed. But maybe I'm not getting it correct. Maybe I'm not correctly understanding what happened. I had a hard time figuring out exactly when Burke's out of the case.
Yeah, it's a little ambiguous because the plaintiff had a different attorney file a last-minute motion to continue immediately before trial.
That's not a member of Burke's firm?
Not at all. And that motion was denied with sanctions. It's unfortunate that despite Burke's attempts to get out, the probate court really had him by the collar and they would not let him out. So I do think Justice Ditkoff, Attorney Burke was the trial attorney on the day of the incident in Barnstable County. But you know, the claim or the issue about not adequately advancing the medical condition of the plaintiff as a basis for further continuances is something that's absolutely replete through years of handling the case, right? It is the same claim that she raises with regard to the March of 2016 deposition issue in Baltimore. And moreover, I would argue that, you know, the fact that another attorney from a different law firm had sought a continuance based on her medical condition and was denied in the Barnstable case is also strong evidence that even if Attorney Burke had handled the medical records differently, the Barnstable probate judge was not granting a continuance. The case was old, the case needed to be tried, I think was the bench's view of it. Another issue which I don't think I'm going to argue at great length, but it is in my brief, allegation of legal malpractice is not self-proving. There's not a liability expert on the plaintiff's side here. Different cases in Massachusetts have found that that alone is a basis for summary judgment in favor of a defendant attorney in a legal malpractice case where the allegations of malpractice are not clear or self-proving. I would argue that this case is a complicated case. It's not a clear self-proving case. Very briefly, my brother had mentioned the continuing tort and the continuing violation principles in his brief. To the extent that he's looking at those doctrines and not the continuing representation doctrine, which I've already addressed, I don't believe continuing tort or continuing violation applies in a legal malpractice context. I believe the appropriate body of case law would be the continuing representation body, which I've addressed. If there are no other questions, I'll rest on my briefs.
One moment, and I'll check with the panel. See none here. No further questions for either one of you. Thank you very much for your arguments. They were very helpful.
Thank you.
We're finished with our hearing oral arguments today, so the court will stand in recess.
Thank you.
All rise.